My lord, very fastly, my lord. First working day in the new year. Happy New Year to your lordships.
Happy New Year, your
Happy New Year.
Yes.
My lord, I am praying leave to move and file an appeal without certified copy.
What service matter? Mandamus appeal.
Mandamus appeal.
When was the order passed?
Just one day before vacation.
When did you apply for certified copy?
Very next day.
So what is the urgency?
Urgency is this, my lord. My lord, the grounds of rejection is I have mentioned the matter before the learned single bench for returnable date. But matter was appeared and learned judge, my lord, dismissed the matter on the ground that there is no urgency. You mislead the court, so matter is dismissed on merit.
Very good. Then what is the urgency?
Urgency is this.
Certified copy.
Urgency is this, my lord. My lord, kindly.
The certified copy. This cannot be a matter of course, granting of leave. It is not a case that heaven will fall if you don't.
No. That is not. But
So very
upon my going to
Sorry, Mr.
going to fill up the post, my lord, going to fill up the post of supervisor. But they are already started to fill up the post of supervisor. Though there is a provision that 50% post.
Show us that they are going to fill it up. Show us.
That is, my lord, I have written, my lord, in.
What material you have to say that it is going to be filled up?
Yes, but they have already started, my lord.
How do we know that they have started?
But I have.
Did you apply for the selection process?
Yes.
You applied
Yes.
for participation in the selection process.
I have participated, but there is a provision that.
Who was that line that you participated? This is not a matter of course. Everybody will come and say, "We don't need certified copy." Advocates must stop at some juncture. It is not a matter of course that every day you will come and say that I have applied, give me. Then you make appropriate approach to the Chief Justice for deletion of the schools of certified copy. Yes, next.
Grateful, my lord.
I am praying for inclusion as my application as motion stage. The application is very urgent. Honorable single chair.
What you want?
Actually, I am praying for inclusion as motion. My
Give the
application.
copy.
Lord, may I have my lords?
Yes.
Kindly, Lord. Lord, this matter I several times mentioned. Your Lordship directed me to mention it in the month of January so that it can be placed in the fairly at the top of the list. Lord, it is
in the combined list.
It is in the combined list 167 item.
So do you remind us on next Monday when the combined list comes out?
Lord,
Yes.
next Monday.
Yes.
Upgradation.
Upgradation you mention on Monday. Let the combined list come. Yes.
Your Lordship, this is for the upgradation and early hearing.
Yes.
Your Lordship, on
It's in the-
20th of December, Your Lordship,
Mention when it comes out on 8th, we will be having the combined.
yes,
This
8th
is
of
the reason,
January.
Lordship. I just want it on the top. Of the...
Is it there?
Yes, Lordship. That's for the monthly
Yeah.
list. It's already here in the.
Very good. You remind us on 8th because the number will be changed. Yes.
Yes,
Your Lordship, on 20th of December, Your Lordship was pleased to pass an order directing the matter to be fixed at 11 a.m. on 5th of January, Your Lordship. This is the matter wherein the director of EZCC's appointment is challenged, Your Lordship. The learned ASD had to make his submissions. He has some difficulty at 11 a.m. He was praying if the matter could be taken up at 2 p.m., Your Lordship.
Let it start. Let it
At
start.
2 p.m. if it could
Come
be
at
taken up,
5. You are his junior.
Your
You
Lordship.
take notes. We cannot alter the date every day. Yes.
Your Lordship, same day at 2
Lordship.
p.m. I was requesting.
May I be permitted to mention application for
Be here by 11 as we have directed. You ought to have told us that don't fix it at 11 when the matter was fixed.
Your Lordship, some constitutional matters have come up which requires him
It's
to
also a constitutional bench. How do you
Lordship.
make such submissions, madam?
constitutional validity of virus has
This is
been.
a constitutional
I bow
bench. We are not concerned as to which bench is taking up what matters because it was fixed in presence of yours. Yes.
Your Lordship, may I be permitted to mention a restoration application for inclusion in the list, Your Lordship?
My lord, may I be permitted to mention item number 318 to 322 of the combined list, last combined list, my lord, which are assigned contempt applications, my lord. Your lordship may remember those matters were,
What you are mentioning for, Mr.
my lord, for taking up the matter on the available day when your lordship would,
Remind us when the combined is come.
on 8th, grateful, your lordship, grateful.
Should I appear in this matter for the
Yes. Every day you please for what is this?
For the Union of India petitioner, the learned Administrative Tribunal Calcutta bench has passed the judgment in favor of the respondent.
Sit down.
The two respondents were there. Actually, they were the applicants before the learned tribunal. Now, the judgment has gone in favor of the applicants. The thing is this, they were selected for promotion to Group B in the post of Rajbhasha Adhikari. Rajbhasha Adhikari. One advertisement.
1 second.
Yes.
He also on
He is appearing in person for two.
yes,
Have you served the
yes, yeah, I have served. At that time, you yes,
You have a senior, sir. Tell your senior and then at this.
Yes,
এটা সার্ভ হয়েছে রাঁচিতে কিন্তু পোস্টেড হয়ে গেছে এখানে সার্ভিস করা আছে
he has been served, he is personally appearing,
No,
but the first
the
respondent,
other one is not interested, she will not come.
the first
My
respondent,
sister wants to know whether you have served upon.
yes, the first respondent was served by speed post at Ranchi. But subsequently, as I am told, she has been transferred from Ranchi. Whether service has been effected upon her or not, that is not.
It is your office, Mr. Roy. She is working in your office and you don't know where is she.
খড়গপুরে ও অন বিহাফ অফ খড়গপুরে ও নিয়েছি
না না একে কোথায় পাঠিয়েছি রাঁচিতে
যখন ছিল রাঁচিতে পাঠিয়েছি তারপরে
পেয়েছি
যখন
না
আমাকে
পাইনি?
ওই তো পেয়েছে ডেলিভার্ড হয়েছে
delivered. Goods have been delivered.
You have the affidavit of
Yes,
service?
yes.
Have checked up, Mr. Roy, delivered?
Yes. 4/12/2023, item delivered to Rita Kaya.
Very good. Yes. Yes, Mr. Roy.
Affidavit করে দিন। I shall file the affidavit of service in course of this day because it is due to be affirmed. It is due to be affirmed.
No, no.
Now, the judgment has
There were two separate original applications.
no single origin.
দুটো সেপারেট
Both
নিচে দুটো ছিল
না না এখানে কোথায়
The order begins saying that
Order
since both the matters.
yes
দেওয়ার কোর্টে
the single order was passed in two separate applications in two separate original application
One preferred by Rita and the other preferred by,
Rajendra Dubey.
then you have to file two separate petitions.
সিঙ্গেল অর্ডার হয়েছে
That order was combined.
Very good, but the applicant in the respective applications were different. There were two separate matters. So you ought to have preferred an appeal against the other one also. That means you are accepting it is in the
So,
case of Rita.
but in fact, if your lordship sees the order,
Yes, analogous.
not only analogous, first petitioner is Rita Kayam and second is Rajendra Dubey. So, and the order is combined, the order, your lordship sees two separate OA number is there. That is correct. But serial number 1 is Rita Kayam and serial number 2 is Rajendra Dubey. Therefore, this is
1210 Rita Kayam, 1209 Rajendra Dubey.
right.
So
right.
that is the two applications.
Two applications.
What is the procedure here? Whether two applications means two writ petitions or only one writ petition?
But since the order is single or combined, in a single writ petition, this can be challenged subject to your lordship's kind consideration, Lord. Whatever I understand, Lord.
Sometimes you can exercise and say that she is not interested in the matter. No, not for sadness. What
is the relief?
what was the relief claimed by Rita?
Same relief. Same relief. Because they were given promotion to the grade B, that is Raj Bhasha Adhikari, after being selected in response to advertisement.
But Mr. Roy, suppose we hold against you.
No,
Then both the application stands alone.
if
You are going to take that risk.
if I am permitted to just make 3-line submission.
Yes,
Then,
what we are asking is, suppose upon hearing you, we decide against you.
right.
Then what will you be doing?
If your lordship,
order.
if your lordship decides against me, lord, then the order passed by the learned tribunal would remain valid, because we have come before your lordship to invalidate the order passed by the learned tribunal.
But kindly come to paragraph 9 of the order. It speaks of only one applicant here. It speaks of only one applicant. Order of 30th July 21 is quashed.
Yes.
This 30th July 21 order is an order passed in respect of both the applicants.
Lord, it is in respect of both the applicants. Please to be
In respect of both the applicants. That is page 50, na? 30th of July.
For the sake of speaking order, speaking order the 51
So this was order passed in respect of Rita.
51 51 51
just a minute.
Okay.
15.
1-5.
1-5. This is, I think, one page number, sir.
In respect of both the applicants.
Page 15.
15. Application. It is his application. Rajendra.
Page 7 the order of 30th July 22. Okay, that is page 50. Type
Okay.
previous page you see, but this is only in respect of Rita. Now, in which order did you challenge before the tribunal?
37
Mr. Dubey,
Yes, my lord.
earlier original application was filed by Rita,
Myself.
but page 50 says that it was of Rita. Page 50. In compliance.
My original application number 1209.
Kindly come to page 50, 50.
50.
নেক্সট করা হয়নি মনে হচ্ছে
Page numbers also changed.
ওটা মনে হয় অ্যানেক্স করা হয়নি দুটো অর্ডার ছিল কিন্তু ওটা অ্যানেক্স করা হয়নি ওটা
Page number 50.
দুটোই সেপারেট
Whether 22 or 50, you just check it at both.
এটা দুটোই রিপ্লাই দেওয়া হয়েছে কিন্তু ওটা কি হয়েছে এত ইলিজিবল করে মানে ক্লার্ক বাদ দিয়ে
Same
দিচ্ছে
order in both of these papers. One is 22 and one is 50. By a single order, their promotional orders were
ওখানে
sent.
আমাদের আছে ওখানে ওখানে দেওয়া আছে
But two separate speaking orders were passed.
Focus notice.
My order was at 21 page, my lord.
Focus notice.
No, that is show cause.
Numbers are-
Speaking order.
That's what page.
Neither the page numbers tally, nor your
See, these two, the
23.
page number 50 is imbued order, 22 is in our type, in my typeset.
20
Mr. Roy, there were two separate orders
Right now.
rejecting the claim of the applicant one, the respondent one, and respondent two.
Right.
Cause of action was that order.
That's correct.
That led to filing of an original,
Yes.
separate original.
Yes.
But one did not contest. Because this applicant, then who is the applicant? It is Rita or Mr. Dubey? The tribunal's order says the applicant.
Both.
এইটা হচ্ছে রাজেন্দ্র দেবের 1209
Notice notice
আর
to
একটা হচ্ছে
applicant
1210
and
আর এখানে দেখো চেক অফ নেগেটিভ ফ্যাক্টস আর ডিক্লাইন ফর
This is
ওরিজিনাল
not the procedure, Mr. Roy. You have to file two
Upon-
separate writ petition pertaining to the original application.
That,
This cannot be because
that why it has been filed in a single writ petition. If your lordship kindly see first 3 lines of the order impugned. First
we
three,
have seen that
yes, my lord.
it is analogous taken up. We would have allowed you, but today's think of the issue. Suppose upon hearing we dismiss the application.
Right,
In that case, the tribunal's order has to be complied with.
right,
Now that will be in respect of 2 applicants, both Rita and Dubey.
right, right.
So now you are concerned only with this matter.
No,
Yeah.
I am concerned with
In Dubey's original application, was Rita a party? Rita was not a party. But you have filed the writ petition enclosing her name as respondent number 1.
because my lord, some difficulties, my lord, which appear
See,
from the first
Mr.
page of the
Counsel,
impugned
Mr.
order.
Counsel, the procedure, because we cannot explain the procedure.
No, no.
As
that's-
per the procedure, as per the appellate side rules, you have to file 2 writ petitions. When they file 2 applications, even though it is a common order, you have to file 2 separate applications. You have to follow the same thing and file it through separate writ petition.
Lord, may I suggest one thing, Lord? Whatever has been said by your lordship, I bow down to your lordship. But my lord, now one writ petition has been filed. Lord, we need not challenge the second application.
Then you
because-
have to comply with Ria's order.
He
Lord,
Then you have
if
to give promotion to Ria.
no, Lord, in the event,
has
in
to restrict to- he has to cut her name.
How
No.
can she include
No.
how can you include Rita's name in this writ petition, Mr. Rai? Rita was not a party in
Yes.
respect of the original application writ petition which you have filed. See your writ petition. It is difficult to explain.
no, I understand. Lord.
You take it as even if you succeed, you have to comply. Then you have to restrict your case only with regard to,
That's correct, Lord. That's correct.
you have to
Therefore,
comply
Lord,
that order.
what I should pray before your lordship, not let me have the liberty to file another writ petition, because this can be treated as a writ petition challenging the order passed in favor of Mr. Dubey.
So that is OA number 1210. Then you have to change, you have to correct all the number and applicant's respondent's name, everything. He has to correct it.
Lord,
2 names will be
Delete
there.
করার একটা হিসেবে আরেকটা তাহলে ফাইল
Yes.
Lord,
Even
if
the prayers, he has to say only
ডিলিট করার পর
he has to type 2 number 1210, 1209. Then he has to restrict to only 1 number here. He has to make a correction or amendment.
This way, how can this
No.
happen? You have to withdraw and file the writ
Right.
petition.
two separate writ
On the
petitions.
prayer of Mr. Royal appearing for the
That with liberty to file 2 separate writ petitions. Accordingly, permission granted to file.
Mr. Royal
নাম্বারটা আমার কোনো ঠিক থাকে দেখবো আমি মনে হয় ভুল করি কিন্তু এখন ভুল করি
Rather,
ঠিক আছে এটা
liberty to file 2 separate writ petitions. Nobody is granted. And writ petition dismissed as withdrawn. Just 2 orders.
liberty.
And then we detail. When we address 2 writ petitions, since he has filed 1 writ petition challenging 2 applications, liberty is granted to withdraw the writ petition as
এখানে
well as
অ্যামেন্ডমেন্ট দরকার
file 2
যদি এটাকে
separate.
লিখে দেয়
Mr. Royal ordered the advocate appearing for the petitioners, upon instruction, press for leave to withdraw the present petition with liberty to file
2 separate.
2 separate writ petitions challenging the order dated, challenging the order dated
29/5/23.
29 May 2023.
এখান থেকে তুলতে পারবো
Passed in the original application being OA 350/01209/2021 and the order dated 29 May passed in the original application being 350/01210.
Zero nine one zero. Yes, both he said 1210. 1209, 1210.
Pen drive right. In view thereof, this petition is dismissed as withdrawn with liberty, aspect.
Only one thing, Lord, may I get the certified copy back, Lord? May I get the certified copy back?
The department is directed to return the certified copy of the order.
Only one.
একটা তুলতে হবে
Sinapa, one copy.
That he will pay at upon retaining a Xerox copy of this.
I'm extremely grateful to my lord.
When you file the other one, you take leave. If you don't have another certified copy, you take leave from us and file.
I will obtain another certified copy, Lord. One is
My lord,
here.
may I be allowed to say something?
No, we have dismissed their application.
Yes, they are not complying the CAT orders, honorable tribunal order, and I am suffering. My retirement is very near. My retirement March, my lord.
Comply with the order. The thing is that
রেডি আছে শুধু পেটিশনটা আলাদা
yes,
Yes,
we has to file.
that way, yes.
That you is not like you. Why this Rita is no longer interested?
She is not interested, my lord, at all. She is telling that I have been transferred from here to there and I am getting too much loss, financial loss, and being a lady, it is very difficult for me to cope up with this. That is the point. And 6 months not complied by railway administration. I'm going to retire.
This I have to go to entire.
Strictly by the rules to Rita, but question of suffering. If he goes and file contempt, they will say High Court has given us leave to challenge. Give us some more time.
He will decide.
Lord, even if he retires, that would not stand in the way
In the
because he would get the financial benefit.
in the identical case in Bilaspur, they are not reverted by the administration as they got stay from tribunal, and I did not get. So even after in my favor decision of the CAT, they are not complying this. In Bilaspur, right from beginning, they are at the post. Their case is not disposed of still, but they are enjoying the post because they have got a stay order, and I couldn't get a stay order from the beginning from the honorable tribunal, sir, my lord.
Where is your original application? Do you have your original application?
Yes, my lord, my original application.
Has it been annexed?
Yes, my lord, annexed by the railways from page number 13 to 13 onward.
What is this?
Yes, you argued. Mr. The present petition has been preferred, challenging an order dated 29 May 2023, passed in the original.
Order of the Honorable Tribunal, Jabalpur bench, my lord. At
Wait,
page
wait, wait. Passed in the original application being OA 350/1209 of 2021. Mr. Royal and Advocate accordingly prays for leave to make necessary correction in the cost type.
Stating as well as in the prayer. Stating as a new order.
Because
No,
Even in the prayer, he is asking to set aside both orders. If you see there, really.
Mr. Royal and Advocate appearing for the petitioners prays for leave to make necessary correction in the cost title and prayer portion of the writ petition, as the same had been preferred, challenging the order dated 29 May 2023, passed in the original application being OA 350/01209 of 2020. You have to cancel Rita Kayam and
yes,
incorporate Rajendra Dubey. Numbers you have to cancel.
yes,
Explain to your
Yes.
properly. And in the prayer portion and cost title, there is also you have to slash,
Rita Kayam.
and in the prayer it will be ordered if another original application.
That would be deleted. But
Deleted.
another prayer, my lord, if you give me liberty to challenge the order in respect of Rita Kayam.
That is always there. We have not said that you cannot pay for this. Yes. Argue.
Yes.
What is the matter?
Yes.
my lord, page number 39.
আপনি বসুন, আমি বলিনি তারপর আপনি বলবেন। Lord, বসুন। Lord, the promotion was given to grade B to the respondent. Now, Lord, they qualified in a selection process and given the promotion to the post of Rajbhasha Adhikari, that is from C to B. Upgradation was from C to B. Now, Lord,
Was that notification?
yes. Notification. Advertisement.
Advertisement at 25
Page?
page. এটারই পরে আছে।
Page.
32।
No, এটা তো উইলিং এলিজিবল স্টাফ। এটা নোটিফিকেশন কেন হবে?
এটাই তো 25 এই।
Lord, if your lordship advertisement
নেই। এটা তো তারপরে হলো সিলেক্ট হলো। এইটার বেসিসে ওটা
if your lordship kindly.
Page 32
Yes.
was the advertisement.
Now, this is the communication to the concerned railway authorities for making a list of willing eligible staff of Rajbhasha for formation of panel of Rajbhasha Adhikari Group B, page 32.
We want to see the letter of 6th December 2019,
6th December.
by which the applicants were invited.
Page number 36.
36. Yes, it is page 36, Mr. Roy.
Yes, just a minute. Yes. Yes. Selection for formation of panel.
Yes.
Now, Lord, it has been decided, the date is very important. If your lordship kindly take a note. The office letter of event number dated 18 November 2019. It has been decided by the competent authority that the written examination for filling up of the vacancies unreserved to and SC1 of SCM SCO Group B against 70% quota will be held on 4 January 2020, Saturday at Southeastern Railway Commercial Headquarters Office, NKG Building, so and so.
What
Kolkata.
is this ACM SEO Group B? That first
Assistant,
paragraph you just now read?
yes, assistant,
Where is this Rajbhasha or something like that? Promotion was, you invited them for promotion for selection to the post of Rajbhasha Odhikari Group B. That is what the tribunal records.
yes.
Where do we find that Rajbhasha Odhikari in this advertisement? Anyway, he will explain to us.
No, that is there.
Now thereafter, very good. Then what happened?
But thereafter, both of them, Mr. Dubey and Kayam, both of them qualified in the written examination as well as the other tests as prescribed by the advertisement. Now, Lord, so selection was made, they qualified in the selection test and they were upgraded to grade B from grade C. They were allowed to join the upgraded post, both of them. They were allowed to join, and Lord, they continued for some time. Lord, suddenly, Lord, the decision was taken by the headquarters that the grade upgraded B post would go to upgraded post A, and B would.
Where is that memo?
Yes,
20th July 2020.
Yes, 20. Lord, if will not you kindly come to page 20. Lord, first, Lord, kindly see, Lord, page 20. This is the communication by the railway board.
Page 20.
Page 20.
18th of November
Yes.
2020.
Yes. Meanwhile, they have been allowed to join.
That's all right. Very
Yes.
good.
Now, Lord, upgradation of Group B, post of Rajbhasha Odhikari, notification number so and so. Notification was dated, Lord, 22nd July 2020. The communication was dated, Lord, 18 November 2020. Now, it has been brought to the notice of the board that two officials of Southeastern Railway, namely Rajendra Dubey, Senior Translator KGP, and Srimati Rita Kayam, Junior Translator KGP, have been impaneled to the erstwhile Group B post. Erstwhile, if you should kindly take a note, Lord, erstwhile Group B post of Rajbhasha Odhikari in terms of Railway's notification dated 20th July 2020, after categorization of these posts as Group A in level 10 of pay matrix by pay commission director's letter number so and so dated so and so. Therefore, as the said empanelment is invalid, it is desired that suitable corrective action may please be immediately taken by Southeastern Railway. Now, Lord, this communication.
Just one moment. 19th of March was the notification for application.
Right.
That you apply for the post.
Right.
And they were appointed, they were selected, and when were they appointed?
22nd.
But on
এটা সাপ্লিমেন্টারি এপিসোড দেওয়া আছে এই যে
yes. Yes, but they were given appointment on 22nd July 2020.
22nd July 2020.
Yes.
They were given appointment.
They were given appointment to the grade B post. Now, Lord,
As
Rajbhasha Odhikari.
Rajbhasha Odhikari.
Yes. Now, Lord, this communication dated 18 November 2020 came subsequently because of COVID. Because of COVID. At that point of time.
What does this notification says have been impaneled to the erstwhile Group B post in terms of railway notification 20th July 2020. Where do we find this 20th July?
23. 23 is
No, no, 20,
20.
2007-2020.
20 হচ্ছে written test 20
That would be, the course,
20
that is reflected in at page 23. If your lordship kindly see, that is dated 20th April 2020, which is also mentioned in letter dated 18th November 2020. Page 23, if your lordship sees,
28th April 2020.
yes.
আর ওইটা হচ্ছে 33 পেজে আছে ওটা 33 পেজে আছে পেজ নাম্বার 33 হ্যাঁ এই যে ট্রান্সফার করা
No, this is page 23, 28th April 2020.
Yes, that is also mentioned in the letter dated 18th November 2020.
But that is not mentioned in the page 20.
Yes, that is also mentioned.
Where do you,
No.
20, acha.
White Pay Commission Director letter number so and so dated 20th April 2020.
No, we are asking for 20th July notification.
Page 33.
ট্রান্সফার পেজ 33 33
বললাম তো 33.
আজকে টাইপ কপি আছে
33A is the typed copy.
And page 30. No, and 28th April is at which page?
23.
20
Page?
Page 23.
Page 20.
Page 20.
বুঝলি
1979.
Very good.
Now, my lord, after since they were continuing in the post to which they qualified for being appointed, and accordingly they were appointed, the communication from the office, competent authority, letter dated 18 November 2020, came after.
Their appointment and posting.
Yes, and meanwhile they were continuing. So after receipt of this letter, what did we do? We just gave them a show cause.
Where is that?
That is at page 21.
Yes.
And thereafter, they were challenging this show cause, approached the learned tribunal. Questioning this show cause, they approached the learned tribunal. The learned tribunal directed the competent authority to pass a speaking order after hearing them. The speaking order was passed.
So originally, another.
Yes, that was the first round of litigation. In the second round of litigation, they challenged the speaking order. The speaking order was quashed and set aside by the learned tribunal, and judgment was in favor of the respondent. Being aggrieved, we have questioned the judgment of the tribunal.
What is the date of speaking order?
Page 51, date 30th July 2021.
30th July 2021. Page 22.
Yes. If your lordship kindly sees,
Now, the thing is, if the tribunal's order has to be complied with, then in spite of serving in a group B post, he would be getting the group A salary.
that is not possible because group A salary, grade A salary is much higher than grade B. The grade B is nowhere, that is abolished. From C to A, and A, if they want to qualify for A, certain criterions are there.
Now, place page 23, the order basing upon which you issued the show cause.
Page 23.
Yes,
Yes.
28th April 2020.
Yes. Revision of pay structure of Group B gazetted post of Official Language Department of Zonal Railways at par with so and so cadre. The issue regarding
So this came prior to their appointment also, because their appointment was on 21st of July 2020. Bhaiva was
Yes.
9th July.
Yes.
21st July 2020, they were given appointment.
Right, Lord.
Now your circular came prior to that. That is on 28th April.
Right.
2020.
Right. But the
Now let us see the first paragraph.
yes. The issue regarding revised pay structure of gazetted post of official language cadre on zonal railway at par with those existing in central secretariat official language service has been under examination in consultation with the Ministry of Finance. The President is now pleased to decide that pay structure of Group B gazetted post of official language cadre of zonal railways may be upgraded.
So this was a recommendation. Maybe up.
Right. Now let the first kindly see the Roman I.
Then don't upgrade. Who is asking him to upgrade? Give him the salary of Group B. We are not saying you pay him Group C. Your challenge, if we have understood that we have Group B post in which he was promoted, no longer exists to be a Group B post.
Right, Lord.
It is now a Group A post.
So
And in support of that, you place reliance upon 28th April order.
yes.
28th April order is a suggestion that it may be structured.
No, not only 20.
Replace.
No, not only 28th April.
No, 28th April, what it has said.
It is recommendation.
That it may be upgraded.
Right.
You are not asking him to upgrade. You pay him his salary as a group.
The question of only problem is this, Lord. I also applied my mind, whatever is your lordship is thinking, because Lord, the consequence would be this, Lord. If the grade B pay is given to them, the question of reversion would
Reversion to what?
reversion to C. No, because if your lordship sees the order, the first order passed by tribunal, first order. If your lordship kindly have a look to first order.
Yes, please.
Just a minute.
11 July.
দেখলাম তো আমি।
Most they have abolished, but the
That page 56.
existence, what he says is not in existence. When the circular has to 28th, they gave circular first day.
In existence, he said, taking support of 28th April, which says that group B, which is that has to be good.
While the circular was there,
There they are
27
Now, if your lordship sees page 56.
Just. Page 56.
Yes.
No, your show cause must reveal that why did you issue the show cause? Reason is given in the show cause. No?
Yes.
That
was challenged. That the show cause itself was challenged.
No. What was the reason in
Yes.
the show cause?
Yes.
Page 21.
28 April.
Meanwhile, pay commission by memo such and such has revised the pay structure.
Right.
It has not revised. It was merely a proposal. And may
21.
receive statement
Yes.
such and such are
Proposed to the-
invalid consequent upon categorization of posts as groups A in the pay matrix. They are saying are invalid consequent upon categorization as group C.
Yeah, in
That
level
don't
10
be
of
written.
28, in the letter dated 28, 420.
That is page 33. Oh, sorry, that is page
Page
23.
23.
The structure of group B will be updated as pay structure of group B. Recruitment will be brought at bar. This recruitment rules will be the new recruitment. Once the application is effective, further instruction procedure for placement of existing incumbents in lower grade to be having a change of which should separate. So now they can according to framework rule that as you are appointed prior to revision of the pay structure, you will give only the post salary.
The salary must be given.
We are not commenting on it. Yes, Mr. Roy.
Yes,
what you want to
I was just drawing your lordship's kind attention to page 56. The first order, order passed in the first original application.
Page 56.
Page 56. Now, my lord, if your lordship kindly turns page 57,
Yes.
paragraph 5. Therefore, without entering into the merits of this matter, we direct the applicant to give reply to the show cause notice dated so and so within above mentioned period, and respondents after receiving the reply to the show cause notice shall consider the same in accordance with law and to pass a reasoned and speaking order within a period of 2 months thereafter. Paragraph 6. Till such time, the reversion from present post to former post of the applicant will not be given effect to. So that was the interim order. While disposing of the OA, this protection was given to the applicant. So after speaking order was passed, we reiterated our stand that this is the difficulty for which your reversion is consequential. Your reversion is consequential. Therefore, reversion was done, that was challenged. And speaking order was passed, that was challenged.
Where is the order of reversion?
Yeah, next for us.
এইটাই তো আছে, এই 21 ফলক 21
না, এটা শো করছে
20 তো বললো আমাদের করতে রিভার্সন
Page 20.
28
page 22.
Right copy is 22A. That is the order, speaking order, by which you reverted.
Yes.
But the group C post.
আঠাশ পাঁচের একটা আঠাশ আঠাশ পাঁচের একটা
Same duty, since railway previously only put advice to pencil
এটা নয়, এটা তো বহুবার
promotion pursuant since the existence has become nothing but away from the
That's what I must. The existence of means what they mean.
Mr. Rai,
Yes.
kindly come to page 51A that you are speaking order.
Yes.
This is
Yes.
Mr. Karamso.
Yes.
Kindly come to the last paragraph. Hence, railway board being appropriate authority advised this railway to cancel the panel published on 20th of July.
Right.
To cancel the panel published on 20th of July
Yes.
for promotion to VDA letters 18/11/2020.
Yes.
Where is this letter?
That is there, page 20. Page 20, which was the basis for their reversion.
18-11
Page 20.
18, 11, 20.
So where is that is page 20.
Yes.
Where is the cancellation?
20, 27,
Yeah, page 20
Page
says
30,
it has been brought
page
to
32,
notice such and
page
such.
33.
Therefore, is
It has to-
empanelment is
Invalid.
suitable correct.
Yes.
That empanelment itself invalid.
Null and void with effect from.
They are proceeding that there is no existence of it.
That's what, how, from where they say. From where
Yes.
they say.
There is no existence. Your reasoning is on 18th of November 2020,
Yes.
empanel was declared to be invalid.
Right.
Huh?
Right.
But he is observing that the post became null and void with effect from 28th of April.
Yes.
Post does not become null and void. Post is there. Scale is upgraded. Is
No,
it
no,
not,
no,
Mr.
that post is not there. I have taken instruction. I held a conference with my client.
So
They-
show us the letter by which you have abolished the post.
That's what I say.
Your contention is due to such upgradation.
Yes.
Today there is no existence of the post of Rajbons. Show us that letter.
B grade is not.
No,
there.
B grade.
B grade.
Rajbhasha Adhikari post is there, but grade B is abolished.
So the post is there.
Yes.
Scale is different.
Scale is
Then
different.
how can you say that the post is non-existent?
B grade. Raja certification was given to the person from C Raja
पहले तो सेकंड बोल रहा हूँ
C grade to group B. Group B. Now according to him, group B is not there. Directly they have to go to A. Group A.
No, group B is there. You are saying group B post is not there. You are saying Rajbhasha Adhikari is not there.
No, Rajbhasha Adhikari is there.
Rajbhasha Adhikari post is there.
Post is there, but that is upgraded to A. They qualified for B.
Council, please clarify. Rajbhas Adhikari, group C is there, group A is there. Rajbhas Adhikari, there are 3 groups originally. Now, Rajbhas Adhikari, group B is not there, according to you.
Yes, Lord. That is my instruction. That is my instruction. C. So they were reverted to C. And if they want to go to A,
So when did you abolish that post? Where is that order? You have given them promotion
yes,
in July 2020 to B grade. Rajbhas Adhikari B grade.
right.
When it was abolished, according to
The
you?
28th July, 28th April 2020,
Then when it was abolished, then why did you give promotion?
because of delayed communication of 18/11/2020 due to COVID. Delayed communication.
Rajbhasha Adhikari post is there.
No, no, Rajbhas Adhikari.
Same Rajbhasha Adhikari.
No. C is senior translator.
C is
Senior translator.
C is senior translator. Achha,
Right.
very good.
Which senior translator?
Grade C.
Group C, I was senior translator.
Right. That I am saying.
Group C is senior translator. Now next.
Next promotion to Rajbhasha Adhikari was grade B, for which they qualified.
Hmm.
But with effect from 20th April 2004, 2020, that post became null and void.
Where do you find that, Mr.
But if your lordship sees,
Post is there. Rajbhasha Adhikari group B post is there, but it is treated in the pay structure of group A. That is done.
no, that is a different post. Lord.
See, council, even on 18/11/2020, you say that post has become that the empanelment is invalid. But where is that invalid notification?
No,
See, yes, now we understand, but where is that notification? According to you, group B is invalid.
because of 28/04/2020. If your lordship kindly see page 23.
Yes.
So group B post will be upgraded to group A.
No, not, your lordship kindly see I, Roman I, page 23, Roman I.
Yes.
The pay structure of Group B gazetted post of official language department of zonal railways will be upgraded from existing payment 2, so and so, level so and so, Group A with designation Rajbhasha Odhikari from the date of issue of this order.
Then according to you, as per this I,
Yes.
per this I,
Yes.
he will be getting the same pay structure, but instead of group B, he will be treated as group A post.
Yes, different pay structure, not same pay structure.
So here you see pay structure of group B will be upgraded from existing.
Yes, upgraded.
Then where is the abolishment of the post, Mr. Roy?
B grade.
No,
Brigade post abolishment, where do you find?
not, with reference to grade B pay structure, the Rajbhasha Odhikari.
Pay is one thing. Pay is one thing, post is another.
No,
Your
it is not,
contention
it is in my respectful submission, Lord, it is connected. Why I tell you, Lordship, it is
So
connected.
let us understand.
Yes.
You are saying we have revised the pay structure
Yes,
by which Rajbhasha Odhikari Group B post will be getting a pay of Group A post.
right.
But where is the abolishment of Rajbhasha Odhikari Group B post?
Because
To see that,
No,
that you
because-
have in view of this recommendation of alteration of pay structure, we have swiped away the Group B post. Show us that. Your problem is that if you allow him to work as Rajbhasha Odhikari as a Group B,
right.
he may raise a plea that since there is a division, you give me pay, scale of pay. That is a separate issue altogether. But how can you throw him out from the Group B post, Mr.
See, from this letter 28/4/20, you cannot say that post has been post abolished or non-existence.
No, Lord, this is not.
Now, even now, you get instruction and show us that post has been abolished.
No, Lord, grade B, if your Lordship, just my very small submission, my submission is confined to this only, that they were promoted to grade B. They were promoted to grade B with reference to the post of Rajbhasha Odhikari. Now, Lord, Rajbhasha Odhikari has been upgraded to a pay of grade A.
Where is it?
That is there.
No.
Aye.
This pay structure from this order, we will not accept that post has been upgraded to group A.
But,
There must be separate order. If there is no separate order, then B grade is there. That's what we can understand.
I, Roman I. If your Lordship sees Roman I.
Will be up.
If your Lordship kindly sees Roman I.
Yes.
Page 23, Roman I. Lord, may I just read for your Lordship's convenience, Lord? The pay structure of Group B, gazetted post of official language, Department of Zonal Railways, will be upgraded from existing payment to so and so Group A with designation Rajbhasha Odhikari. Therefore, Rajbhasha Odhikari is no longer a post of grade B.
Your argument, but clause 1 says the pay structure. The pay structure will be upgraded. Does it mean that there is no Group B post?
No, there is no Group B post of Rajbhasha Odhikari. Rajbhasha Odhikari has been upgraded. That is my whole submission.
Rajbhasha has not been upgraded. You have upgraded the pay structure. Read
So
clause
earlier Rajbhasha was belonging to B.
Right.
Now Rajbhasha Odhikari is belonging to A.
No. Then you would have said that the Group B Rajbhasha Odhikari post is hereby cancelled, abolished.
Nothing is there.
Clause 1 says you are upgrading the pay structure. Upgradation of pay structure is one thing. Abolition of the post is another thing. Why abolition? Because if it is abolished, there are thousands of persons working under you as Group B. Due to this problem, where you are feeling the pain, that today if we do not interfere, tomorrow he will come and say pay structure revise, give me pay A. Then the problem is
No, another aspect is also there. Kindly appreciate. They qualified for grade B, not for grade A. Your Lordship, kindly consider this. They qualified for grade B, not for grade A. Therefore, they cannot just not upgrade themselves to grade A without being qualified.
Show us the wrong order then, order which you have challenged. What is the reasoning given by the tribunal?
Last.
Paragraph 7.
Paragraph, paragraph 7, right? We find.
Yes, place it.
We find that the filling up of 2 unreserved vacancies for the post of Rajbhasha Adhikari Group B was initiated by letter number so and so. The selection process commenced with the issuance of this notification. However, after more than 1 year, the process was completed with the promotion of the applicant to the post of Rajbhasha Adhikari with a memorandum dated 20th July 2020. Meanwhile, in pursuance of the recommendations of the 6th Pay Commission, the post of Rajbhasha Adhikari was upgraded to grade A post, and the respondents, after issuing show cause notice to the applicant and after considering the reply, reverted him to his substantive lower post of Group C, vide their order dated 30th July 2021. RB number so and so states, inter alia, any selection LDCs which has already been notified should be completed as per the existing instructions only. Para 7 RB so and so dated so is quoted below. Government of India, Ministry of Railway, 19th March 2019. Instruction so and so, any selection LDC which has already been notified should be concluded as per the existing instructions only, and the new instructions would apply for those selections LDCs which are notified after the date of issue of these instructions. However, the instructions referred in the circular pertain to the pattern of written examination held as per selection, as part of selections LDC for promotion to Group B post, RB number so and so, is therefore not relevant to the instant matter. We are, however, of the view that since the applicant was promoted to Group B post of Rajbhasha Adhikari on the basis of existing rules and after following a process which lasted for nearly 1 year, it would not be proper to revert her to her lower substantive post. Moreover, this would also be against the principles of fairness and equity. In view of this, so this is the reasoning. This is the reasoning. Since they qualified as per notification and they are already promoted, reversion would be improper against fairness and equity.
কোন টেস্ট করলো
Apply for selection which are notified after the date of issue of these instructions.
অনুযায়ী হবে যেটাতে সেই সময় তো ওটাই প্রধান করছে
because selection was on 22nd July 2020. Yes. As per existing instructions only. The new instruction would apply for selection of the date of issue of these instructions. That means 19/3/20. How does this go with this? However, instructions referred to in the circular pertain at a written examination held as part of the selection for is therefore not relevant. How considered admission of individual
mobile tone still now. All are in group B still now. Upgradation process will be started, my lord, on the basis of this 16 January 2023 order. It is under process, but not implemented so far.
But your promotion order says
Yes.
that is your promotion order is at page 33, no? Following provisional panel promoted to Rajbasa Odhikari.
Yes, my lord. Group B.
Then you were working in group B post, in this post.
Yes, my lord, I was working in group B post.
Group B post after you were promoted on 21st of July 2020, 20th July.
20th July.
You joined.
Yes, my lord, I joined.
Where do we find that?
In the
Rajbhasha
Rajbhasha Group B post. My appointment order is also given in this supplementary affidavit, my lord.
Was that?
It is on, my lord, in page number 5.
Page number 5.
Page number 5.
It is 22nd July. That is on the very next day. At that time, this notification was there.
28. But according to them, it was not communicated to the concerned person.
Due to COVID.
That's what applicant.
Appointed to office.
Office order number 144 by 2020.
As the approval of general manager.
Now, clause C, we may opt for fixation of liability from the date of promotion as per externals, subject to further guidelines.
Whether he opted for further
Dated
fixation of the
is early. His fixation has not yet been.
fixation of the date within 1 month.
Within 1 month of date of promotion. That will be as per date. We are not concerned with that. We will say would be whether we say and not we did. That is a matter to be studied.
Before they can do it.
We must decide the
Order of reversal.
reversion. Yes.
Yes, my lord. On 22 July 2020, I got promotion order for appointment to Rajbhasa Adhikari Group B, Gazette post. Subsequently, I joined on 24th July 2020.
24th July you joined.
I joined.
Yes.
And I got my, on page number 6, I got my identity card.
Yes.
On 12/8/2020.
Yes.
Then on page number 7, I first draw my salary after 1 month in August 2020. RBA Group B Gazette.
Where you are reading?
My lord.
Page 7.
Page 7, my pay salary, my lord.
Yes.
Second line says, bill unit number 702-219, GAZ Gazetted Post 106, serial number. And post name RBA, short form of Rajbhasha Adhikari.
Post, where is it?
Fifth line. Fifth line starting, designation RBA.
Yes. Now you were given the Group B salary.
Group B salary, my lord.
You were saying that you are not being given the Group B salary.
After reversion, my lord. but they did not deducted the salary for 1 year, which was given in Rajbhasa Adhikari. It was not even after reversion, salary was not deducted.
The earlier payment was not deducted.
Earlier payment was given.
After reversion, subsequently, they have not paid B grade for salary,
Yes, my lord.
but they have not made any deduction.
Any deduction.
Yes.
Because I went to Honorable Tribunal for justice. The matter was sub judice.
Page 20. He filed writ petition, the OA, but was not decided on.
Group B level 8. Level 8, my lord.
Gradation given. 28 for 2020, they have not communicated. But by the time they were given appointment and paid salary also to the B grade, subsequently they reverted. But the previous one,
before reversion, they should
receive notice. Whatever.
in equity and fairness, right? Thing is, as we say, that
How many posts are there on the like 37 for it? They have given post to B grade.
no, they can take this time. That you will be satisfied with you be satisfied. These are the parties have to be given level 11.
Then
He has been given, say, level 10. Post is there, post has not been. Now the question is whether as B, he can now claim automatically group A scheme. That is a separate issue.
that means they have to go.
Fresh adjudication. But how is reversion? Reversion is only after this is there was a proposal for application.
That is the case when contributing when he is eligible for B grade, when the post is not there. But now he is eligible for
Yes, now it becomes a
Yes, my lord. So my prayer is that I should be given Group B salary and Rajbhasa Adhikari post. Reversion order is already quest, my lord.
What about another tribunal order you are saying?
Another tribunal order is on page number. In Jabalpur tribunal, the matter is not decided, but they have already got stay order, so they are still on the post of Rajbhasa Adhikari Group B. They are not reverted. And it
But are you now saying that since I have got promotion to Group B and since the pay structure has been revised, you have to give me Group A salary, though I am working in Group B?
no, my lord, still in railways, no Rajbhasa Adhikari is placed in Group A pay structure, and pay structure is effected from 2023, January 2023, and all officers are getting Group 8, sorry, Rajbhasa Adhikari Group B level 8 salary.
Level 8 salary.
Level 8 salary.
Now then why clause 11, which you are showing us, page, kindly come to, you just now showed us the recruitment rules. Clause 11, Rajbhasha Adhikari is level 10, page 14 of your supplementary evidence.
It is with effect from 16 January 2023, after the notification in the Gazette of India by the Railway Board. And I was reverted on 30th July 2021.
saying Rajbhasha Adhikari Group B, you are enjoying level 8.
Yes, my lord.
Where do we find that? Level 8
Level 8 in my salary slip, my lord.
in your salary slip.
In my salary slip, it is already mentioned.
Where
Level
is that?
8.
Page 7, level
Page
level 7 it is given.
actually 3 months they it was level 7. Then they paid arrear. Page number 8, my lord.
Level 8.
Page level 8, and I got also arrear for last 3 months.
So now kindly come to page 14. In terms of the new rules, there is no Rajbhasha Adhikari post having a level 10 grade. Rajbhasha Adhikari in level 10.
Level 10.
Then who gets level 10? You are Rajbhasha Adhikari level 8.
Level 8, yes, my lord. And all officers in my head office also.
The chronology. First group C, then senior.
Group C, junior translator and senior translator.
Wait. Junior and senior translator.
Group C.
Yes.
Thereafter, Rajbhasha Adhikari, Group B, level 8.
Level 8. Yes.
Senior translator, level 7.
That is also group B.
Group C, senior translator, Group C.
Group C is junior and senior translator.
Yes.
Group B is Rajbhasha Adhikari.
Rajbhasha Adhikari,
level 8.
level 8.
Then next.
Then it is decided that it will be upgraded to Group A, like the CSOLS, on the pattern of CSOLS. This was a recommendation of the 6th CPC in 2026, which was implemented by other ministries in 2015, but in railways, it is implemented from 2023. And in the later, it is said that the existing Group B will be upgraded after the Gazette notification.
That is 16 January 2023.
1623. There is provision for existing Group B officers for upgradation. So since I was also one of the existing Group B, so when others will get Group A status, then I will get Group A status. Others are not getting, I will also be not getting. But they reverted only me and Rita Kaim, not others. Nobody in the Indian Railways reverted. Only I and Rita Kaim, because she is also in this panel and she is junior to me. Only 2 persons are reverted in all over India.
When post is not there. No, what it says, applicant says, it is not the same. Post is not there. In that case, how others are working?
He is not saying post is not. This, how others are working? That is a wrong interpretation. Now, what I was thinking is he is getting level 8. Today, if I dismiss them, they must be very paying level 8. Because that is still a Rajbhasha Adhikari post.
What is the post on the same field, he will get. But if you have full field, that is different.
I will not comment on that. This is only a yes.
My lord, at the time of selection, everybody was in Group B. I was also in Group B, and still they are getting level 8 Group B salary.
No, you were promoted from Group C to
Group C to B, and they are also promoted from Group C to B.
That is in respect of others.
In respect of others.
But asking you, you are getting level 8.
Level 8.
After this new rule has come into process,
yes,
you become entitled to which level? Where it is said that Rajbhasha Adhikari Group B will be treated as Group A?
My lord, it was on page number 20. Page number 20.
Yes.
In writ petition, page number, page number 20, my lord. No, 23, my lord. Page number 23, item number 4. Item number Roman 4. It says, once the upgradation of post from PB GP 4800 level 8 to PB3 GP rupees 5400 level 10 is effective, which is effected from 2023 January. Further instructions regarding procedure for placement of existing incumbents in lower grade to higher upgraded post and change of RR recruitment rules will be issued separately by the management of service directorate. By the management of service directorate, which is still in progress. These rules are not effective still today. And I have been reverted 3 years before.
28th July. So that's what this we are not able to see. This is also not.
And my lord, this item has been suppressed by the railway administration all the time.
This is 21/7/23. No, 21st July 23. It's not here. Date of 20th July. The 20th July is their appointment. So therefore now they are according to them it is estival post. Therefore post is not there.
Yes,
According
not
to
been
them.
able to show that the
No,
post
that
is-
is that's what. From where they say estival post. How do they say that? That we are not, he is not able to.
All right. Yes, Mr. Roy.
But I was only troubling your lordship by submitting that in the event the impugn judgment sustains, but where my learned friend would be fitted. That is the whole problem.
As you have given the pay level 8, he will get whatever you have paid to him. We are not saying he will be entitled to pay
Because
of
he
A grade. Level 10 or A grade we are not going to see.
it is whether he is entitled to level 10 or group A, we are not concerned. There is no abolishment of the post, there is revision of pay structure, Mr.
That's
But
correct.
your understanding, your argument is this contention has the it can be inferred from
Right.
the circumstances
Right.
that the post stands abolished.
Because Rajbhasha Adhikari now is upgrade to A.
Pay structure.
Yes, A and level 10. He was
Yes.
level 8 is up. So while I know that this deep necessary correction, we have to
Acha, you first make the correction. This is correction. You
Can I give my copy first for correction, then we will see that until you dictate, you will dictate corrections they have to carry here or in the department.
show you. Where is your petition? Got the petition?
Yes, ma'am.
Kindly come to second page, verses.
Yes.
You have to cancel one. Struck down one. and the number 2. You have to strike down 1 and number 2. See number 2, it will be the applicant ground. Got it? Only number 2, not the entirety of it. Huh?
Yes, ma'am.
Now this correction as per leave. Kindly come to the bottom of that page, order dated 29 such and such. It will be his application is
1209.
120 and 350 slash and such, that you have to cancel.
They're going through.
And 350 slash such and such you have to cancel.
Pen through.
Huh?
Pen through.
Huh. So you don't have a pencil?
Yes, ma'am.
Yeah, clear. यही देखो
काटा नहीं
then every we will say prostrated and clear.
That is no.
Got it? So how you have started?
Page 2.
1 you have to cancel.
1 I cancel, start down. The number of the 2.
এই শোনো এটা কি কাট না এটা কারেকশনটা নাম্বারটা এটা কি
This name will not be there and this number won't be there. Only one respondent. And then he also, instead of respondent, he has to say respondent.
এইটা পুরোটা না
Yes, yes.
show him.
করে দিন এই এটা তাই করেছি
1 2 and at the bottom respondent applicant. And in the last para, last cost title and 350, that will be stand deleted.
Yes.
And in the prayer portion, prayer A and such deleted.
দেখে করে নিন
And 350 1210.
Is it?
Now got it?
Yes, ma'am.
Okay, return.
Business.
Application is raised for leave to make they are portion of the requisition application slipper challenging the order dated 29,000 past in the original way number 350/01209/20.
Can you say that in that place, restricting their relief in the present petition only with regard to 350/1209? Restricting. That they cannot challenge.
He said that he has prayed for it.
Okay.
Still, if you find it,
I'm asking you whether you have to say that.
I could
in view thereof, the challenging next further in view thereof, this petition
you can't give this benefit to him.
is treated in the prayer of such I think about it.
Yes, yes.
Mr. Royal Learned Advocate appearing for the petitioner submits that the learned tribunal allowed the original application preferred by the respondent hearing only on the principles of fairness and equity, without appreciating the relevant recruitment rules in force. such infirmity warrants interference of this court. Drawing our attention to a memo dated 18th November 2020, annexed at page 20 of the decision, Mr. Roy submits that the respondent's empanelment was rightly held to be invalid in view of the railway notification dated 28th of April 2020 from a composite reading of the contents of the notification dated 28th April 2020 and the notification dated 20th July 2020. It can be inferred that there is no existence of the post of Group B post of Rajbhasha Odhikari. Such argument was glossed over by the learned tribunal and no finding was returned on the same. Per contra, Mr. Rajendra Dubey, the respondent appearing in person, submits that he had been penalized for no fault on his part. Responding to the railway notification, he applied for the Group B post of Rajbhasha Odhikari. Such application was accepted and he was called for a written test on 29 November 2019. Upon emerging to be successful, he was again called for the vivacity test on 9th of July 2020 and was appointed and was promoted to the said post of Rajbhasha Adhikari bracketed group by an order dated 22nd July 2020. And since then, he was functioning in the concerned post and was granted the appropriate pay scale. In support of such contention, he has drawn our attention to the notification, to the memo dated 20th July 2020, 22nd July 2020, and
Joined on 24/7/2020.
appointed and was allowed to join.
By an order dated 22nd,
20. Thereafter he was appointed on. Thereafter he was allowed to join on 24th of July 2020. He further argues No. Drawing our attention to a notification dated 16 January 2023, annexed at page 12 of the supplementary affidavit, he argues that at the time of argues that the post of Rajbhasha Adhikari bracketed group B has not been abolished. Furthermore, the purported recruitment rules. Furthermore, the Indian Railways official language department bracketed group A post bracket close recruitment rules, 2023 came into effect. It came into effect almost about 2 years after the petitioner was promoted and allowed to join the post of Rajbhasha Adhikari. In the said conspectus, the learned tribunal has rightly set aside the order of reversal dated dated 30th of July 2020. Heard the learned advocates appealing for the respective parties and considered the materials on record. So, indisputably,
এগুলো সবই as per you হচ্ছে এখানে আমি তখন সবই as per you shutdown and delay shutdown
by a memo dated 25th June 2019, the competent authority decided to initiate the group bracketed inverted comma B selection for the post of Rajbhasha Adhikari bracketed group B for filling up to first paragraph, page 32 the page for filling up to unreserved UR vacancies as intimated by Deputy CPO bracketed GAZ / GRC VDA letter dated 21st June 2019. The name of the respondent duly featured in this report. Thereafter, he was called for a written test on 29th of November 2019 and a viva voce test on 9 July 2020. Stop. Having emerged to be successful in the selection process, he was promoted to the group B post by a memo dated 22nd July 2020, and was allowed to join on 24th July 2020. No, supplementary. And was granted the level H. The contention of the petitioners that the post of Rajbhasha Adhikari bracketed B had been abolished, had rightly been discounted, had been rightly discounted, as there was no as from the memo dated 28th April 2020, it was evident that there was a revision of pay structure and not abolition of the post. The new rule, the new recruitment rules also came into effect much after the respondent was selected and promoted and allowed to join the post of Rajbhasha Group B staff. The authorities also paid him the level 8 scale of pay. Level 8 scale of pay. In the said conspectus, the respondent ought not to have been reverted, as there was no laches or fault was attributable to the said respondent. Stuff. The learned tribunal, upon granting the learned tribunal by a recent order had exercised discretion in favor of the respondent upon arriving at specific findings, and we do not find any infirmity in the said review thereof. The petition such and such is dismissed. There shall, however, be no
My lord, compliance by the administration. I pray for compliance by the administration.
contempt, na? You have filed a contempt application.
No, my lord. They are not complying the order of the tribunal.
That is an issue to be considered by the tribunal. We have rejected their petition. We
Yes,
have rejected their petition.
yes,
Mr. Royal, if you need
yes, my lord.
We are dismissing. It's for them to comply. Otherwise, it's for the-
Your lordship,
We want to say comply. Since
then contempt.
we are dismissing, that's why we will not say anything.
We have dismissed their petition, Mr. Dubey.
yes, my lord.
Implementation of the tribunal's order, that is not within our domain.
Your orders shall be complied by the administration.
Pardon?
Your order will be complied by the administration.
How can we say
I
that
pray.
they have the opportunity to approach the Supreme Court against our order? That they will come to learn once you file the contempt.
Oh, okay, my lord.
The affidavit of sale.
How long time they will take to comply? Applicants to
If the DD petition is dismissed, the time towards compliance of the order passed by the learned tribunal impugning the present deed petition.
Initially, how long time?
वही देखो नहीं
आगे
time भी नहीं
No time was given, lord.
time was
Set aside, then you let him set aside. Order set aside.
ইন্টারিম অর্ডারটাকে ডিসপোজ করে দিচ্ছি
Set aside, then so we are also.
চাকরি করে
Therefore, the order stand cancelled. They have to automatically they have to comply the order. Comply the order. They have to place him in the original post of Group B and
yes.
pay the
Are you wanting any time towards compliance?
No, lord, I do not have such instruction, lord. I leave it up to your lordship, lord.
We cannot say that, otherwise it will be the problem for him. They have to.
Mr. Dubey, you have to go with the tribunal. We have dismissed the petition. Now, if they do not comply, it is within the domain of the tribunal to call. But Mr. Roy, if this is accepted as a
Lord, I will definitely, lord.
advice,
I think, lord, this he would be again, lord, given the same post which he was holding.
Because even according to him, in all over India, only 2 persons were reverted.
I understand,
Others are
lord, I
working.
understand.
Then you can advise them. That also we can.
I understand.
that all over India,
Except
2% reverted to pure.
we do revert. And
no,
other,
it-
some other persons have filed and obtained interim order and continuing. And others, they have not passed any order. No, we are not concerned with that. We are just
No,
saying.
The affidavit of service failed.
Yes.
if it is make the correction properly. Otherwise-
I just now I
Grateful.
Yes,
May I be permitted to say
sorry.
that?
Yes, all the list. Yes, yes.
Yes, my lord. So the petitioner is an employee of Railway Staff Benefit Fund Committee, my lord. It's a government organization financed from the revenue of the Railway Board from time to time.
Did we hear Mr.
Paper books have been filed, my lord.
That we know.
What was the last date of hearing?
Actually, it was taken up on last day before closing for the. It was fixed on 4th.
Lastly, it was fixed on 4th December, my lord.
But
But
thereafter,
that was not
it
heard.
appeared in your lordship's list on daily basis, but
Yes, tell us.
yes, ma'am. The petitioner.
First place the order, then. we
Yes,
can
my lord.
come
Lordship.
to the point.
Then your lordship kindly come to page 262.
Then you argue.
Page 262, my lord, volume 2 of the paper book. The impugned order is
Page 262.
volume 2 of the paper book. Yes.
Evening.
Let me quite some time. I talk with my colleagues to come. They decided when.
Okay, but
Once it is decided,
you please tell me, I will want to come.
all right. Chandra,
I don't know, I will go to his house and take some flowers and keep it there and come. I will go on the evening. Actually, day after tomorrow.
May I place the order, my lord?
page 260.
262 in the volume 2 of the paper book, my lord. Actually, may I read for you?
Yes.
Actually, in this writ petition, petitioner has prayed for payment of monthly salary and release of arrears salary from 1st April 2014, which according to the petitioner has been stopped after 31st March 2014 in spite of an appointment letter dated 24th of October 1979, which has been issued in favor of the petitioner by the Secretary Headquarters Staff Benefit Fund Committee. It has been contended on behalf of the petitioner by myself, the learned advocate, that non-payment of salary with effect from 1st April 2014 is unjustified and is not tenable, keeping in view of the fact that petitioner was appointed based on appointment letter dated 24th October 1979, specifically wherein it has been provided that service of the petitioner is terminable at any time prior to attaining the age of 70 years on 14 days notice on either side. It has been argued on behalf of the petitioner that the requirement of such notice as contemplated under clause 4 of the appointment letter dated 24th October 1979 has not been complied with while withholding the salary of the petitioner with effect from 1st April 2014. In addition thereto, it has been submitted that a proceeding was initiated in terms of the relevant provision of the Public Premises Eviction of Unauthorized Occupants Act 1971 against the petitioner for disposing him from the quarter which was allotted to the petitioner, including the dispensary which was also allotted in favor of the petitioner being a homeopath. The issue ultimately travelled before this court and coordinate bench while disposing of a civil revisional application being CO number such and such preferred by the petitioner, passed an order on 20th November 2018. It was observed by the coordinate bench that the service of the petitioner continued. Therefore, the petitioner has a right to occupy the premises allotted to him. Based on such observation, it is contended that by no stretch of imagination, petitioner can be considered as discontinued with effect from 1st April 2014. In addition thereto, reliance has been placed on behalf of the petitioner on an order dated 23rd of July 2014 issued on behalf of the Ministry of Railways, Government of India, wherein certain norms were fixed regarding working hours of the Ayurvedic homeopathic consultants. Based on such order dated 23rd July 2014, it has been argued that the right of the petitioner to continue in service has been duly protected by the railway authorities. In addition thereto, it is submitted that the payment of honorarium for the service rendered by the petitioner as homeopath in the railways has been constantly released from the Staff Welfare Benefit Fund. Therefore, the right of the petitioner to continue in service up to 70 years is protected, and service of the petitioner cannot be discontinued in fashion it has been done in the present case. Mr. Shobhan Mukherjee, learned advocate, appears on behalf of the Southeastern Railways and has submitted on placing reliance of the appointment letter of the petitioner dated 24th October 1979 that the nature of appointment given to the petitioner is purely contractual and on temporary basis. Apart from this, it has also been submitted that such appointment has been given for the well-being of the staff of the Southeastern Railways, and the service of the petitioner is not protected by any statutory provisions. Therefore, the petitioner has no right to continue in his service. The attention of this court has also been drawn by the learned advocate representing Southeastern Railway to the fact that previously the petitioner filed one title suit, being title suit number 421 of 2015, for declaration that plaintiff writ petitioner is still in service and is entitled to get his regular salary and is entitled to live in the quarter and to run his chamber, and also permanent injunction restraining the railway authorities from illegally terminating the service of the plaintiff petitioner. However, it has been submitted by both the learned advocates representing the parties that the same suit was withdrawn by order dated 24th February 2020 by the Civil Court. This court has heard the learned advocates representing the parties and perused the relevant documents available on records in order to ascertain the nature of appointment made in favor of the petitioner. This court has no other alternative but to rely upon the appointment letter dated 24th October 1979, where it has been amply made clear that the appointment of the petitioner was on temporary basis and the service was offered to the petitioner was contractual. In addition thereto, this court has also posed query to the learned advocate representing the petitioner whether the service of the petitioner is protected by any statutory provision, but this court is unable to get any satisfactory answer. Only document which has been placed before this court is the order dated 23rd July 2014, wherein certain norms have been set forth relating to the duty hours of homeopath and Ayurvedic doctors who are appointed by the railway authorities for well-being of the staff of the railways. On reading of this order dated 23rd July 2014, as well as a scheme relating to the appointment of the petitioner as homeopath, it appears that no statutory right has been conferred upon the petitioner in relation to his appointment pursuant to such appointment letter dated 24th October 1979. Though the reliance has been placed on the order dated 28th November 2018, passed by the coordinate bench on a civil revisional application, but on consideration of such order, it appears that such order was passed in connection with the proceeding initiated against the petitioner in terms of Public Premises Eviction of Unauthorized Occupants Act 1971, wherein while deciding the issue and the right of the petitioner to occupy quarter, it was observed by the coordinate bench that the petitioner was in service. Such observation by the coordinate bench does not confer right upon the petitioner to continue in service if the same is discontinued by the respondent authorities. In consideration of the above facts, it appears that the petitioner does not have any enforceable legal right in connection with his employment which can be protected by issuance of mandamus. Accordingly, the writ petition was dismissed.
Where was your termination?
Rashi, I was in fact,
No, was your letter of termination?
my letter of termination, which for the first time they have annexed here without serving upon me, Rashi, that is
So
at
why didn't you insist for the termination? Because your case is that I am continuing since 1979.
79
One fine morning you get up and stop my salary.
without any notice.
That is on 1st March 2014. To that, their answer is your service has been terminated as clause 4 of the 1979 memo does not act in your favor. You are temporary. And where is the order of termination?
Now, my lord, may I say to this, the salary and I was
Show us the order of termination first.
letter of termination is at page 195, volume 2.
195.
That is, it was issued on 23rd of May 2016. But it was given a date.
2nd of May. It is 23rd of May.
Yes.
24th May.
23rd, 4th, no, page 195.
190. Yes. What is said? Your salary was stopped from 2014.
2014. It was given a retrospective effect.
What? This letter?
This letter.
Show us. Place it.
Yes, my lord.
Engage.
You are engaged as homeopath practitioner at KGP workshop under the aegis of Staff Benefit Fund by Secretary SBF, letter numbers such and such dated 24/10/1979. The extension for continuation as homeopath practitioner at KGP workshop is granted by the Staff Benefit Fund Committee on yearly basis since then. While working as homeopath practitioner on contractual basis, the privilege facilities like pass, PTOs, and railway accommodations were extended to you. In terms of Railway Board's letter number dated 27/2003, it is clarified that all the engagement under Staff Benefit Fund should be limited to 1 year, and they are not entitled for the above privilege and facilities. Thus, as per the directive issued by the Secretary Staff Benefit Fund, the privilege facilities like pass, PTO, and railway telephone were withdrawn, and you were also advised to vacate the railway accommodation, which is entitled for railway employees and not only employees only, not for the AGS basis engagement. The sanction grant for continuation as homeopathic practitioner at KGP was discontinued by the Staff Benefit Fund Committee from 1/4/2014. On discontinuing of grant from Staff Benefit Fund, the dispensary was closed. As such, your service is deemed to be terminated with effect from 1/4/2014.
Why did you make the Staff Benefit Fund Committee a member?
I have, my lord, firstly,
You have been appointed by
by this Railway Staff Benefit Fund Committee.
They are not
Now,
participants.
when they attempted to throw me out, my lord,
No, Mr. Roy, we are asking why didn't you include them in this dispute?
my lord, I have made them party.
Because your appointment was on the basis of 27/1979 letter,
Yes.
in which the railways have no role to
No, railway have the role of supervision and administration, and they, in the capacity of appointing authority, senior divisional personnel officer in this divisional level, and this principal chief personnel officer in the state level, my lord, they have the power to engage me.
What is that letter of 1979?
Yes, my lord. That is at page 41 of the paper book, volume 1. Yes. You kindly see the language used here. The scheme is financed by the Staff Benefit Fund Committee of Southeastern Railway. Roshi has found, my lord.
41. Typed copy is the 41 in the next page.
Yes.
Roshi, the scheme is financed by the Staff Benefit Fund Committee of Southeastern Railway. You will be appointed on a fixed salary of 300 per month, chargeable to the Staff Benefit Fund without any allowance whatsoever. The appointment will be purely temporary. Now, my lord, kindly see the next things. The employment is a full-time one, and you will not be permitted to take up any other part-time, full-time employment under any other authority or individual.
What is your age?
My age is at present 68.
At present, 68.
At present 68, my lord. I have only 2 years of service left. I have been provided with the official quarter and the dispensary. I am attending that with their authority.
Sir,
Yes, my lord.
Age is 68 in 2014 or 24?
2024.
24?
24.
68.
68. Now, my lord, your normal retirement age will be 70 years, but your service are terminable at any time prior to attaining the age of 70 years on 14 days notice on either side. The Staff Benefit Fund Administration will not be bound to assign any reason for such termination, and this power may be exercised by the additional CME workshop KGP. May I kindly note this one. Roshi was asking me about the authority. This is the authority.
What?
Chief Mechanical Engineer Workshop Kharagpur.
And this power may be exercised.
Yes, may be exercised by the additional Chief Mechanical Engineer Workshop Kharagpur. He is a railway designated authority, my lord. Railway quarters are not guaranteed.
This scheme at paragraph 1.
Yes.
What scheme is financed by Staff Benefit?
Yes, my lord. That scheme I have annexed. The scheme is, lord.
This letter. Anything else you want to show?
Yes, lord, I only want to show in this letter that though the term temporary has been given effect to, but in effect, it is a full-time regular employment. And that has been, lordship, stated in that way in the subsequent Railway Board circulars. And Railway Board circular, I am reading, my lord. Railway quarters are not guaranteed, but when one is available and allotted to you, the monthly rent therefore will be recovered from your salary on the basis of 10% of your emoluments, conservancy, and other charges will also be recoverable extra as per the rules applicable in railway employees with similar pay, my lord. The working hours of the homeopathy dispensary will be the same as those of the branch dispensary Kharagpur or may be fixed by the additional CME. The homeopathy dispensary may be normally be closed on the afternoon on Saturdays, on completely on Sundays. In addition, homeopathy dispensary may also remain closed on the afternoon of such other days when the branch homeopathy dispensary remains closed. Now, my lord, next, private practice is admissible provided it does not interfere with your duties in connection with the homeopathy dispensary. My lord, kindly come to clause 10. Passes and PTs will also be issued as admissible to the employees born under the Staff Benefit Fund organization. On completion of 1 year service, 10 days leave with full pay in a year is admissible. Total accumulation of leave will be full pay would be 30 days, of which maximum 20 days leave may be availed in a single spell. My lord, this is the appointment letter. Now the scheme lordship wants to see. I have attended. I have annexed. Lordship, kindly come to page 43. This is the Railway Staff Benefit Fund. Okay. Page 43. Page 43, my lord, of the volume 1. Yes. My lord, this is the scheme. My lord, in the last paragraph of page 43, clause 805, it says, in addition to the credits to the fund,
Railway Staff Benefit
Fund
Scheme.
It's a fund. So under this scheme, the committee is formed.
Where do we find that scheme? It is a Railway Staff Benefit Fund.
Yes, my lord. That
Where is the scheme you are talking about full-time engagement? This appointment letter refers to paragraph 1.
My lord, only I want.
Is financed by the Staff Benefit Fund.
Yes.
So the Staff Benefit Fund has been created for funding the scheme.
Yes, and all the fund comes from the revenues of the railway board. That is the app.
Mr. Roy, we are asking you, where is that scheme by virtue of which this appointment letter was issued to you?
My lord, it is.
Your case is.
Yes. Kindly come to page 45, my lord.
Page 45.
Page 45.
Yes, page 45.
As you kindly see under the heading Management of Fund.
Clause 807.
807.
Yes.
The fund shall be managed by the committee at the headquarters of the railway, presided over by Chief Personnel Officer. Besides.
Management of the fund.
Yes, I have been appointed by these designated officers. In the divisional level.
No, now we are asking, brother is asking you, come to page 41. Come to page 41. See, first number, class 1.
Yes,
Class 1. The scheme is financed by Staff Benefit Fund Committee. So now, scheme is different, Staff Benefit Fund Committee is different. That scheme
listen.
Yes, sir.
So scheme is financed by Staff Benefit Fund Committee. So now we are referring Staff Benefit Fund Committee. So now brother is asking, where is the scheme?
My lord, probably.
No, probably won't help, Mr. Roy. Your writ petition has been dismissed on the ground that this has no statutory flavor. This appointment does not confer upon you any right to continue till 70 years.
My lord, may I say only
When
this?
this has been, this fund scheme has been discontinued, fund has been.
No, my lord. My respectful submission is this. Lordship will peruse.
To show the scheme, then you should argue. Where is the scheme under which you were appointed? We are not accepting any.
Lordship, kindly see this.
We are concerned with the records. What we will show, you show us this.
No, probably that it is not appearing there.
So then,
my lord, may I say, my lord? It's a quasi-railway organization, Staff Benefit Fund Committee. Railway organization.
Quasi-railway organization.
It's coming under quasi-railway organization, that is Staff Benefit Fund Committee.
Staff Benefit Fund Committee.
It's appearing here.
That is what Staff Benefit Fund Committee has appointed you.
Yes. No, Staff Benefit Fund Committee.
Where is the scheme under which they have been appointed?
Scheme, my lord, this is appearing in the Indian Railway Establishment Manual. And
Please, Mr. Roy, you cannot go beyond the rules.
no, I'm not going beyond the rules, my lord.
You are not in a position to show us the scheme. That is your essence of your right. Show us the scheme.
The scheme is, my lord, what is appearing in the page 43.
Under the staff benefit fund. Scheme is financed by staff benefit fund committee. What is the scheme?
Yes, is there any scheme?
But actually, my lord, there is the scheme is stated to be the appointment letter. My lord, what is stated in the appointment letter? This is the whole thing that he has been appointed by the scheme means that my lord, he has been appointed by the sub benefit committee, and his salary will be paid by the
From the staff
revenues.
benefit fund.
But sub benefit fund. This is the nothing is there, my lord. He cannot show. Actually, he cannot show whatever he is claiming. He cannot show.
Now, my lord, only thing is this. There is a railway board circular to this extent with regard to appointment of.
Here not that was not before the report. We can see only what you have placed and argued before the report.
And may I read only this thing? Well, this has a bearing upon the outcome of the report.
Why didn't you take it?
Because it came late to me, my lord. This is already because I am.
Petition, why didn't you argue this?
I was not having this particular circular in there.
So
Now,
you could have craved
now, my lord, may I say this? The staff benefit fund committee, my lord, is financially, administratively regulated by the railway board. It is appearing from this letter of 1989. Now, my lord, the same thing is reiterated in the staff benefit fund committee's constitution, which I have annexed here.
807.
Yes. Now, thing is this, my lord, they have appointed me, and under their clause, they said that it's a temporary appointment. But from the latter provisions, it transpires that is a regular employment.
So, Mr. Rai, you are challenging your alleged termination. There is no order of termination given by the staff benefit fund committee.
Yes. My submission
Why
respect.
didn't you make staff benefit fund committee a party? Then we had called upon them that where is the letter of termination? Because clause 4 says that you cannot be terminated without appropriate reason
Yes.
and by an order.
But that was not served upon me. That is my number one submission.
So for that you have to make the staff benefit fund committee a member of this.
But what I have made the officers, lordship, the designated officers as a party in the proceedings, who constitutes the staff benefit fund committee.
Yes. Anything else, Mr. Rai?
No. My thing is this, my lord. This letter of termination which they are harping at present. Firstly, my lord, it was not served upon me when the proceedings was.
Repeat.
When
note of what you have
when the
said.
proceedings was initiated under the Public Premises Eviction Act, there the court below, the trial court below, my lord, repeatedly said, is there any termination letter? They said no. This is of 2015. I have initiated that proceedings. Now, when the matter approached before the Honorable High Court, my lord, they also did not say that I have been terminated and let the Honorable Court pass a direction that my service is still continuing. Now, I have been, after the Honorable High Court's order, my lord, I have taken out one contempt application as because they were not giving me back my possession and the dispensary. On the strength of the contempt application, my lord, they have given me my dispensary and the official quarter, which has a correlation with the service. I am at present in possession of the official quarter and at present in possession of the dispensary where I am attending, and they are signing up on that attendant register. So now, my lord, my respectful submission is this. I am still in service because of this reason. The termination letter which they have issued, they themselves has diluted it. They themselves has undone it by restoring back all the facilities which I was entitled to. Now, when they are enjoying my service, they should at least pay my salary, which I am entitled to. And under the railway board circulars, my lord, my service is protected. But you kindly come to once the circulars at least. The railway board circular which guides my service conditions. Kindly page 65, my lord, kindly come.
Kindly come to page 265. Don't take us for a roving inquiry. Come to page 260. What is the finding of the court?
Finding of the court is this, it is a temporary and contractual.
Contractual. First,
But
second finding is that in addition thereto, this court has also posed a query to the learned advocate as to whether it is protected under any provision or not.
yes, it's
This, it has come to a finding that you have no statutory right to continue.
May I say, my lord, first and foremost,
23rd July, which has been placed before us, is 23rd July 2014. That is
what I am saying, my lord, at page 65. Page 65, volume 1 of the paper book.
Where do you show page 6? 23rd July.
Yes.
61 bol.
Yes.
Yes, my lord.
What is
Yes, Roman 2, my lord. Kindly see this. Roman 2. Page 65A, my lord, is a typed copy. My lord, the existing arrangement.
Yes.
Yes, my lord. Page 65A is a typed copy, my lord.
Yes.
Kindly come to Roman 2 of the said page.
What is this?
It
What is
protects.
this 23rd July 14?
It is a railway board circular, my lord, which says that those
Yes.
doctors who have 8 hours, my lord, may I read? The existing arrangement of 8 hourly and 4 hourly dispensary should be.
Subsequent to your termination.
No, it is prior to my termination. Because
2014.
14, because I was
Stopped from
2014, but April.
Yes.
But I have worked till 2015, which is appearing in their letter. I have brought that letter with me also.
What do you want to show?
I want to show, my lord, that as I was appointed as a regular one, I say, my lord, because it is an 8 hourly job. The existing arrangement of 8 hourly and 4 hourly dispensary should be replaced with 4 hourly dispensary working any 5 days in a week. However, the existing practitioners working in 8 hours dispensary may be allowed to continue till their current contract expires. No further extension will be given to them. Now, my lord, I am 8 hour working as an 8 hourly doctors. So I should, my only prayer before your lordship is this.
Problem. You are relying upon the 79 appointment letter.
Which is regulated by these circulars.
79 appointment letter read with page 195 is that your yearly contract will be renewed.
No, my lord, I do not fall under that category. My respectful submission is this: a demarcation has been made of 8 hours employment and 4 hours employment. I was appointed as 8 hours employment. And now
appointment as 8 hours.
It's a regular employment, my lord. Kindly see. 4 hours was introduced. 4-hour job was introduced later on in 2013-14, which appears here.
No. In the appointment order itself, it has been stated your retirement age will be 70, but your services are terminable at any time before attaining to 70 years.
Yes, but there is no termination at all. I say because that termination letter was not served upon me, not shown before this court on several occasions. For the first time only in this writ petition, they have annexed this termination letter.
They will take benefit of your glasses. You did not make the staff recruitment fund committee a party to this petition.
No, my lord,
then the court could have arrived at an adverse finding.
My lord, staff benefit fund committee, the designated officers who comprises.
Forget about that. Why you are unnecessarily saying that? We also know that they are railway officials. One thing, record sticks to the pin. Court is putting a question to you.
That they have not
prevented you from implementing them that you have terminated me. Show us the letter of termination. And unnecessarily, the person is being dragged from 2014 till date.
May I say one thing, my lord? When I filed this writ,
Proceedings.
yes, when I filed this writ petition, my lord, this letter of termination was not with me. Neither the letter of termination was with my client. The letter of termination was for the very first time was annexed in the affidavit in opposition
Where is that?
by them.
Page 195 you showed us. Page 195 which you showed us. That is the letter of the
Page 162, there is opposition. 162 the
195 is the letter you showed us.
yes, that is
the letter.
the letter.
So this says something else. This is not the termination. This is of 2016. Your termination is in 2014.
There was no, my lord, by this letter, they have terminated me retrospectively and kept this letter with them. They have not shown this letter to. They have annexed it for the first time in the affidavit in opposition. I didn't have the occasion to challenge this. And now after the facilities were restored, they themselves diluted this letter of termination. And no provision will say that I can be terminated by retrospective effect, where 14 days notice was required to be issued.
Go and file a suit.
My lord, suit.
What will you do?
No, I only want the salary. I am putting my service. They're enjoying my, just a minute. They're enjoying my service. It is not that I am just staying there.
Mr. Roy is over. He made an endeavor. A railway said that we cannot do that.
I should kindly come to the attendant registrars. It has been countersigned by the railways.
Can we force an authority that you allow him to continue unless you show us that there is a statutory provision? You are right, contractual engagement cancelled by a letter, that letter not served upon you principles of violation of natural justice, etc. But show us anything that your service on regular basis is protected under any provision. It is not protected, it is contractual. Question is that whether that can be drastically done. Because Supreme Court has said that even in respect of cases where 311 protection is not there, principles of natural justice has to be followed.
Even, my lord, may I take your lordship to the...
You are not on that point. You are dilly-dally. You are going to other issues.
Because my respectful understanding is this, as this honorable court in a coordinate bench has stated that I am still in service. So when it is reiterated by this honorable court that I am still in service, so I, along with the official quarters and facilities, I should be paid the salaries. And there are other circular, my lord, which also protects my service. So you kindly come to page 135A. 2015 circular is also there. Of the volume 1, 135A.
Yes. 2 years there.
2016, they used to be terminated.
And we are taken up in ages of such and such extension. Yearly. Was your service extended on yearly basis?
No, my lord, I do not come under that category. My service is still 70 years until unless it is terminated through due process of law.
See, one second, if you're 24, if you are 68,
Yes.
then 79, what was your age?
79, my lord, I was in my early 20s.
No, what was your age? What is the date of birth? 24, 68 means 14?
90, 20. That is 24, 44 years.
44 years.
It's 79 means 89, 99, 2009, 2009.
24.
So 45 years service.
Yes.
45 years service. Then now he's 68 years now.
He's 68.
68. So that means 23.
I was 24, my lord. I was 24 when I joined. I was appointed. My lord, only thing I want to impress upon your lordship, kindly come to page 135 for once. Another subsequent circular which protects my service.
Please.
Page 135 of the volume 1.
Volume 1.
Volume,
Yes.
the Roman 2, my lord, again, 2015. The existing consultants working in 8 hours homeopath and Ayurveda dispensary may be allowed to continue with the approval of respective SBF committee. Fresh engagements in this dispensary should be done on 4-hourly basis. My lord, I come under the prior one, 8 hours. And the facility is extended.
This is a letter after your termination.
But I was not aware, but it somehow it gives me a right because I was continuing.
Yes.
I was continuing in my service. And they were enjoying the service. And it's a duty of a public in nature, my lord.
Mr. Roy, you are not in a position to show us the scheme, the very basis on which.
Then in that case, my lordship kindly grants me at least 1 day's adjournment. I will try to come with the scheme because
No adjournment. No adjournment. This is the third time we are hearing the matter.
the scheme is only I have the, my lord, the constitution which I have annexed.
Where is the order of the High Court in the civil division?
Yes. Page 89.
Are you still utilizing his services?
No, my lord, actually,
They haven't handed over the dispensaries to me.
my lord, giving full
Ask only one question.
This is answering, my lord. Just answer.
Yes or no? Are you?
No.
Very good. Sit down. Yes.
Page 89A.
89.
Yes, my lord.
That was in connection with the suit.
No, my lord. Suit I filed in the year 2015 as because there was a recurrent threat of termination. Now that became invalid after they issued the eviction order under the Public Premises Eviction Act, which prompted me to file a misappeal before the district judge. The district court held in favor of me that I am still in service because no termination has been effected upon me. That is the finding of the district judge. Now, as there was some anomaly in the last portion of the order, it compelled the petitioner to approach before the civil revisional jurisdiction.
What anomaly?
Anomaly is this: after holding everything in my favor, it was said that misappeal was dismissed. So only for this reason, my lord, I preferred the revisional application before this Honorable High Court. This is the order, page 89A. Now, after that, they themselves cancelled the order of eviction and restored me all the bungalow and the
What
building.
is that page?
That page 121. This is after the Honorable Court's order.
122.
121, my lord.
121.
Yes.
15th April 2019.
Yes, 24th April 2019, my lord, in obedience to Honorable High Court's order dated 28/11/2018, issued in the matter of A.K. Sharma versus Workshop Person Officer, and as per the direction issued by such and such, the office eviction order dated issued in the matter of eviction case number is treated cancelled. So I have been restored with the official quarter and the dispensary, and they have complied.
And you are working.
Yes, I am attending the service.
What was your salary in March 2020?
my lord,
It was
that
stopped 14.
till 2014, my lord, till 2014, the day I was, my salary was stopped, my lord, I was getting, which I have annexed at page 47, 21,000 rupees. And also, in addition to that, medical allowances were also being provided so that I can purchase the medicines. These were all stopped.
When was the eviction order passed?
Eviction order was passed, my lord, on 7th of June 2017.
Where is that eviction order?
That is at page 75. Typed copy, my lord, next page.
Page
Page 75A. 75A is a typed copy, my lord. And it also deals with my service conditions also, wrongly stating that I have been engaged on 4-hourly basis. Kindly see the tenor of this. Last paragraph.
Do you have the allotment order of your quarter?
Yes, my lord. Page 74, previous page.
Allotment was in 93.
Yes, my lord. Page 74, it says of 12th of November 1993.
You're allotted the quarter.
Yes, I was allotted with the quarter. And same quarter till date I am enjoying, pursuant to Honorable High Court's direction.
Then where is the order cancelling such allotment? Against which you preferred a
That is at page 75A, my lord. This
75A.
This is the eviction order. I challenge this under the application section 9, and order has also been annexed here.
Now, where is this railway board circular of 2nd July 2003?
No, that is not there. That is not there with me, my lord.
That is not?
There with me right now. 2003 lordship is not there with me. I have the subsequent circulars of 2014 and 15.
No. 2nd July 2003 circular says that it is renewable every 1 year.
That is in respect of those who have been appointed on 4-hourly basis.
How do you say so?
Because this is because of this reason of the subsequent circulars which demarcates the two things. 8 hours.
So does the circular where?
Page, my lord. First circular is at page 65. Yes, page 65A, room clause 2. Existing arrangement of 8-hourly and 4-hourly dispensaries should be replaced with 4-hourly dispensaries. However, the existing practitioners working in 8 hours dispensary may be allowed to continue till their current contract expires.
Till current contract means which?
With the contract.
Contract is for 1 year.
Only 2 years is remaining.
No. Contract is for every year they will renew.
But the question of renewal comes only on respect of 4 hours.
Salary stop. Stop 2016. Salary stop April from March.
2016 he got this.
The salary was stopped from 1/4/2014. Whether you were allowed to work from 1/4/2014?
Yes, I worked there. After for 1 year, thereafter also. There is a notice, my lord, which
Oh, till 2015?
15 I have worked, but they have not paid me. That is there.
Now, why you are saying you are still working?
Because, Lordship, because the dispensary was reallocated to me after Honorable High Court's order, I'm attending my dispensaries. I'm purchasing medicines from my own funding, my lord, and I'm treating the patients. Because official quarter and the dispensary have been reallocated to me. And moreover, Lordship, Honorable High Court's order which says that I am still in service, that has not been challenged before the Honorable Apex Court. They accepted that they have done the wrong thing to me. Because they could have at least challenged this, but they have complied.
That still you are in service?
Yes, my lord. That I have shown, my lord. Again, my lord, kindly come to page 89A. 89A is a typed copy. Last paragraph of that page. It was found by the appellate court in elaborate detail upon consideration of all materials on record that the service of the petitioner continued, including the right of occupancy in respect of the premises in question. This is the finding, my lord, upon which, my lord, they reallocated the bungalow and the official quarter and the dispensary. And they have not challenged this order before the Honorable Apex Court.
Your salary was, your grievance was, your salary was stopped from April 2014, for which you preferred the writ petition in the year 2020.
No, my lord. My salary was stopped in the year 2014. But as because it was followed up with eviction order,
Yes,
I challenged that in the appropriate forum.
we understand. But
Thereafter,
what has that to do with your service from 2014 till 2020? This is now a stale issue. Who will determine that whether you have worked during that period or not? That is why you preferred the title suit.
no, my title suit I preferred much earlier.
Title suit was preferred
In
rightly
2015.
did so. Rightly did so. It was 2015 because your salary was stopped from 2015.
Now, my lord, the prayer made in the title suit all have been, Lordship, merged with this authorities order upon. My lord, I have
2016 order. He claimed only salary.
I have exhausted all the civil remedies, and only upon my right crystallized that I am in service, I approach before this court for disbursement of salary.
Mr. Roy, we could have understood if you could have challenged the subsequent order of 2016 petition.
I never got that, my lord. They themselves annexed it in the affidavit in opposition for the first time. And in the lower court below also, before the trial court, my lord, they suppressed this fact when the honorable court directed them on repeated occasion, if there is any valid termination, they could not be able to produce neither before the lower court nor before the honorable high court in the revisional jurisdiction. Or else the finding could have been different. They never produced that letter. Because I say, my lord, that letter is an illegal letter because nowhere in the terms and condition it is stated that they have the power to terminate me with a retrospective effect. 14 days notice was not given at all. In 16, my lord, that notice of termination was issued, giving it effect from 2014. So I had no occasion to challenge that, my lord. And once they have handed over me the facilities which I am entitled to, they themselves has diluted the effect of that letter of termination. And only when my right crystallized, my lord, then and thereafter I approached before this court for disbursement of salary. Before that, I didn't do so.
2014 when salary was stopped, have you written one communication that show us that how you are terminating me without serving a notice? Show us anything.
My lord,
There are two separate aspects of the matter.
yes.
2014 April, you were terminated. Your contention that this was without any notice, suppose we assume that is a good point. But Mr. Roy, that 2014 stoppage was supported by a purported order dated of 2016, which they did not disclose. You're right, even if we answer. In the midst thereof, what happened? The eviction notice came.
I challenge that.
So the eviction notice is pertaining to occupation of your premises.
But it touching the service conditions also.
You say this is court's order. Your misappeal order was set. Misappeal order was set aside. What was misappeal order? That eviction is good, though observing in your favor.
Yeah.
And that is why the court said that that observation is without you. But that does not. Trial judge said that that does not confer any right upon you to claim regularization of service. Try
No,
to
sure, I
understand.
cannot claim regularization.
So what you will claim?
I only say that, my lord, as there is a
How can we help you, Mr. Roy? Tell us.
My lord, kindly.
After 10 years, 2014, we are in 24.
My lord, kindly come to the page 75A. It does not
The order of
eviction, which I have challenged. Now that has been set aside. Now, my lord, in last paragraph of that order, it touches the service conditions also.
Page 75A.
Yes. It does not stop with the illegal occupation, my lord. It goes beyond that. My lord, I am reading it once again. The above mentioned eviction case has been filed by WPA KGP against you before the estate officer to take back the railway quarter number 207 from your unauthorized possession. In this regard, it is stated that you are engaged as homeopathic practitioner under the Staff Benefit Fund by SBPC for KGP, Homeo such and such with the specific terms and conditions. Railway quarter number 207, Unit 3-4 South Side was allotted to in favor of you by ADRM allotment letter dated such and such. But after issuing of Railway Board's letter dated of 2003, wherein it was reiterated that engagement under Staff Benefit Fund should be limited to 1 year and they should not be given such privileges, facilities which the railway employees entitled. The same was communicated to you, which you have acknowledged by you. I have not got it, my lord. Accordingly, by such and such, it touches the service conditions. Accordingly, by WPA number such and such, you are directed to vacate the said quarter in terms of Railway Board's letter dated. However, the same has not been vacated up till now.
So what is attached with service?
They say that as because it is a yearly renewable service, so it has not been renewed. My case is this, I do not come under that category at all. I come under a different category of 8-hourly dispensary employee. And this has been clarified by the Railway Board later on. At this juncture, Secretary SBB has issued a letter addressed to the chairman, wherein it was stated that facilities extended to Dr. Sharma like railway medical passes, PTO facilities were withdrawn. He was requested to vacate the railway quarter. In spite of requested request by your office, he has not vacated the railway quarter. Due to non-compliance of this office order to vacate. My lord, this has been set aside. So once this has been set aside and they themselves has cancelled it, so their contention that my service is extendable by 1 year and it has not been.
We don't understand that aspect.
My lord,
you are wanting us to infer into something which is not there. Try to understand these are two separate aspects. Your challenge against the illegal eviction has been sustained. High Court has held in your favor.
So it has directly.
Think that now you are saying you are pay me the salary.
Because
how we will determine whether you have worked, how we will determine whether notice was served or not. These ought to have been agitated to you at the appropriate time when you filed the suit. That is why you filed the suit. Bring the suit papers, you have said that.
I have annexed that. Now, my lord, may I say one?
Then come to your averments in the suit. Yes.
No. May I say this one? My lord, I have exhausted all my civil remedies. I have nothing more to gain from the civil court. Because the civil court, through order, my lord, I got back everything except the salary.
No. That is, Mr.
Now, my lord, may I say one thing? My lord, after.
Explain what is your prayer. And when what is withdrawn? Must have been withdrawn after the order of revision bench.
No, no, my lord.
2020.
May I see?
My lord,
I am বলতে না আমাকে
Don't
তো
jump. You may have a good case. Wait.
I have much withdrawn this title suit, my lord, after the writ application was filed.
That's okay.
That is recorded in the division bench order. That is
Let's
recorded.
see that, but show us the claim.
Page 209, my lord.
না না ওটা তো ইনজাংশন
No, no. Title suit. Page 181, my lord.
31 my lord
181 in that. Yes.
You prayed
না
for
এটা ইনজাংশন অ্যাপ্লিকেশন
My lord,
this is the
my lord plaint is at 231 page 231 print
that has withdrawn, my lord. I have withdrawn that. My lord, at present,
kindly come to page 208. That is their stare. And in this one, did you 2016 letter?
nothing. I didn't have any knowledge of that, my lord. I only had the knowledge when I approached before this honorable.
Sought for in that suit. Only temporary injunction restraining them from dispossessing you. Page 186.
Long page, yes, sir.
What is correct?
Where is the
my lord page 231 231 that was injunction application previous one
Yes. There.
They are at page 238.
39
To get regular.
Okay, yeah.
To get postal.
Declaration was short to that.
It's a declaratory in nature.
Is that sort of
It's a product is consulted.
and there is that second first amount after the record is that order of section of allotment.
Yes, my lord, I place that cancellation of allotment,
This page I think one.
cancellation of eviction order is at page 121. Yes, cancellation of the eviction order by them. Yes,
The middle paragraph.
in obedience to Honorable High Court's order dated 28/11/2018.
That I'm showing. Cancellation of allotment where which you challenged in the recess.
Yes, yes. Cancellation of LLC, that is in the eviction order itself. Page 75, which I have challenged in the misappeal.
It's 75. Eviction law.
That is 23rd July 2014. That is the eviction order.
No, that is good.
No, eviction order is, my lord, probably at 2017, page 75A.
Yes. See, that- that issue- This memo, it is very, it is written
Hmm?
Just to what?
Yes, my lord.
No, that
It is the advisory intent.
so railway impacts are different from this. Sir,
Second.
Lordship, kindly allow me to place only one page of the district judge's order, which is at page 85A. One page, I will only submit it. There's a relevancy here. 85A. 85A, my lord, the last paragraph. Volume 1 paper book. May I read, my lord? The respondent claimed that the appellant was no longer in service since 1/4/2014 and therefore had been unauthorizedly illegally enjoying the railway quarter, but did not produce any document of termination of the service of the appellant. However, the appellant has submitted a document denoting and substantiating his attendance in the master role from 26/3/2014 till 31/7/2015, which had been signed by the additional station manager NSHU AC Railway Kharagpur, which established the fact that the appellant had been conducting his duty as homeopathic doctor without any interference being inducted therein. The respondent did not file any document to have effectuated the termination of service of the appellant in view of the directive of the Railway Board dated 18/5/2015.
Where is this? 18/5/2015 Railway Board.
Yes, I have annexed that, my lord. I have just now shown. That is at page 135A. Yes, my lord. The respondent did not file any document to have effectuated the termination of service of the appellant in view of the directive of the Railway Board dated 18/5/2015 and the letter of appointment dated 24/10/1979. Appellant is still in service and shall continue to enjoy the facilities till there is a legal termination of his service as homeopathic doctor.
That is your claim.
But this is the finding of the court, my lord.
The respondent claim.
My lord, next point. As long as the service of the appellant is not terminated by the authority in accordance to the appointment letter dated 24/10/1979, he cannot be considered to be out of service.
Your argument.
My lord, in the last page, that is a finding, my lord, from the directive of the Railway Board.
Kindly come to 85A. The
Yes.
paragraph starts that the respondent claim.
Respondent claim.
That is your argument. Where is the finding?
87A, my lord.
87A, very good, yes. From the directive of Railway Code.
My lord, 86A. 86A, last page, last paragraph. It is pertinent to mention that occupancy of the quarter is directly connected as a corollary to the service benefit and is in conjunction to it and not indistinct. Therefore, if a person is still in service, cannot be evicted on the ground of unauthorized occupant in the opinion of this court, since the right to occupy the quarter is directly connected with the right to continuance in the service. From the directive of the Railway Board, it further appears that the existing practitioner working 8 hours dispensary will be allowed till their current contract expires and no further extension will be given to them, and any fresh employment henceforth should be done only on 4-hourly basis and the contract of the consultant employed in 4-hourly dispensary will be followed for 1 year only and will get extended further, subject to the satisfactory performance of the consultant and the age limit of the aforesaid consultant. That is, one employed for 4 hours dispensary has been fixed at 65 years, and that of the existing consultant will cease to be employed after 65 years of age. The appellant's contract is to expire at the age of 70 years, which is after the age of 65 years. And since he has been in full-time service, the facility of past PTO will be admissible as per entitlement mentioned in such and such only to 8 hours consultant, which stands ratified by directive of the board dated 18/5/2015, which states that the facility extended to the practitioner of 8-hour dispensary prior to the issue of the aforesaid instruction dated 23/7/2004 may continue till such time with the approval of the SBF committee. Therefore, in the opinion of this court, till there is a legal termination of service, the appellant is entitled to all the benefits, including that of the occupancy of the quarter, and is guided by the directive of the Railway Board. My lord, this has been upheld by this Honorable High Court in civil divisional jurisdiction. And they have not challenged it before the Honorable Apex Court.
After saying that, he affirmed it.
For that, my lord, I have to prepare revisional application, and this court has opined that I am still in service. And in the contempt proceedings which I have initiated, my lord, on the basis of that, they have handed over all the benefits to me. Railway quarter, dispensaries, everything.
Now
And
still you are there.
I am still working. They are utilizing my service, but they are not paying.
My lord, first of all, my lord, your lordship has been pleased to ask my learned adversary regarding the learned advocate of the appellant. My lord, regarding the shoot, your lordship has also come to the shoot. My lord, kindly come. I'd like to draw your lordship's kind attention to page number 248. I'm starting from there, my lord. 240. Yeah, sorry.
Yes.
Kindly come to the, my lord, 238. Beg to be excused, my lord, 238. The prayer of the shoot.
Yes.
My lord, the prayer has been made. It may be declared that the plaintiff is still in service and is entitled to get his salary and is entitled to live in quarters and to run this chamber and to get all medicines, salaries, etc., etc. An order of a permanent injunction may be passed, stating defendant illegally terminated. So, my lord, there was a prayer in the suit. Your lordship has correctly hold that the trial court should have is the competent authority to give him the salary. My lord, he filed the suit before filed the writ petition. My lord, suppressing the, my lord, if you lordship will go through the writ petition, if lordship cannot find a single sentence regarding the pendency of the suit. My lord, to avoid the long pendency of the
supplementary affidavit. I filed it prior to
in the main writ petition, my lord, in the main writ petition, there has not been there is no whisper of the pendency of the suit. My lord, at the during the hearing of the writ petition, we pointed out this matter before the Honorable Justice Amrita Sinha when her lordship was taking up the matter, that there is a suit pending with the similar prayer.
So he withdrew.
Yes, my lord. Afterwards, he withdrew, and my lord, kindly is the language of the withdrawal petition. Kindly come to the withdrawal petition. Page number. Petition. Page number 247, my lord.
Yes.
The plaintiff has, may I read you for a lot?
Was the relevant?
Yes. The paragraph number 2. Just a small petition. During pendency of the suit, the defendants passed order for eviction of the plaintiff, such that the plaintiff was compelled to prefer an emission appeal. Having been aggrieved by the order, district that the plaintiff preferred CO suggested before the Honorable High Court, and CO has been disposed of a contest on 28 November 2018. After passing the order, defendants have reinstated the plaintiff to his previous position and has regularized position of the in the quarters. Accordingly, all the grievances, well, an important line. Accordingly, all the grievances of the plaintiff concerning the instant suit has been mitigated. So there is no necessity to proceed with the suit any further. Well, what was the prayer in the suit? That regularize me in the service and pay me the ADR. What he is saying, by affidavit, swearing affidavit, all has been mitigated. Now, my lord, kindly come to the order of the court.
Now, according to you, his quarter has been given back to him.
What, my lord, giving respect to the solemn order of this honorable court, honorable revisional court, we handed over. To avoid any contempt proceeding, etc., we already initiated, we handed over. But my lord, so far his regularization in the or continuation in the service are concerned, my lord, unfortunately, he has not annexed several documents. My lord, may I be permitted to show before your lordship? I have the documents, some letters prior to the 2014.
You should have annexed it in your opposition.
Next opposition.
But go through the other documents. Show us from your opposition.
65 years in 2015. Now 8 years. 33 years.
Yes, Mr. Rai, you affirmed this affidavit, page 248, saying that you are 65 years.
In 2015.
In
2015,
Like 240.
title suit was 2015.
2000.
Yes. My lord, writ petition has been filed out thereafter.
Yes, sir.
Yes, yes.
There you say your age is 65.
In 2015. No, my lord.
Page 248.
Yes, 248. The affidavit.
He filed the petition. for
Arey,
trial.
what's that?
No, my lord, that's probably my lord's a correct file. It's incorrect. It's not the correct.
By swearing affidavit.
248.
248 you signed, Mr. Rai.
No, this is. Oh, this is a letter of withdrawal, my lord.
No.
Petition of withdrawal.
Yes.
Petition of withdrawal, that is 65. That is in. It's a title suit of 2015, but it was a petition was affirmed in 2020-21 for withdrawing the petition. I have to make an application before the court, and that was done 2-3 years back. Lordship, there, my lord, we have to make an application for withdrawal of the suit.
No, we understand. Page 250 is the date of making up the petition. That is of 2020.
20, my lord, yes. So only then, in only 1 year of service.
What date? Subsequently withdrawn without any liberty. Even after filing a motion, he has not petition to challenge the termination order by filing amendment petition.
Yes.
Lord, kindly come to page number 171 of the volume 2.
Yes.
My lord, later dated 26, my lord, he was continuous 171. Was continuously pressing before this honorable court that he was unaware about the termination and etc. My lord, on 26 March 2013, The letter was sent to the Dr. Sharma. My lord, withdrawal of facilities or privileges pass and PTO in favor of the homeopathic doctor. New settlements, Kharagpur Staff Benefit Fund Committee under aegis of SBF. My lord, Deputy CPO's letter number such and such. As per Deputy CPO directions communicated by his letter under reference, you are hereby informed that all the facilities such as past PTO, railway quarters, medical facilities have been stopped immediately.
What is that letter? 18/3/23,
Lord?
2013.
My lord, that was a departmental letter, my lord. That was communicated
Then
to the.
any communication for with regard to termination.
My lord. And my lord, that was sent to the workshop personnel officer. Thereafter, workshop personnel officer sent.
My sister is asking whether 18th of March 2013
My lord.
says anything about termination.
So you have stopped all the facilities in view of the letter
They can
18/3/2013. So in view of the letter 18/3/2013, that means that time itself 18/3/2000 they stopped terminated. That letter, two sections. What is
That has been
that?
That is
That
why
can
when-
that can be-
after withdrawing, we should not have
But that type of it.
how can we know on the basis of the conservation? Saying their decision. Now he's saying that I'm treating this. So what is the procedure the railway employees are sent to these doctors by, or they are
Actually, my lord, actually, if your lordship will see the appointment letter is very much clear on this. Staff Benefit Committee, appointment letter 1979. Staff Benefit Committee, at the very relevant time, used to appoint some doctors on the temporary basis, homeopathic and Ayurvedic doctors. They were allotted some chambers, and it has been specifically stated that quarters, if quarters available, that will be. But the appointment was completely temporary.
you said whole time, full time.
Well, actually, full time means, my lord, if you accept this offer, then you have to work full time. But very particular language administration, it is not a permanent job. It is a temporary job.
Very good. Now you said that there are two ways how we can do away with your service. One is 70 years attend, you will go away.
My lord.
Second is we can issue a 14 days notice.
My lord.
Admittedly, no such notice you could extend.
No, not admittedly. The notice was served in the on. My lord, that has been also mentioned by the Lani single bench in the order, my lord. The protection.
What's that? That notice was served.
Notice was served in the Forum 14. But এটা কোথায় annex করেছো?
তুমি annex নাওই নি আমার annex এর কথা।
That is reflected in the order include.
My lord, kindly come to
162.
yes.
Correct. Yes, where is it? No. Who did not deal with that issue even?
নেই
Yes, show us.
Manuel, kindly come to page 250.
Wait, let him show.
They have countersigned my attendance register of service 257.
Yes, because he is continuing with the dispensary, my lord. Dispensary.
There is the admission.
But there is, my lord, that has this point has been particularly raised by the tenant.
Page 257.
This point has been particularly raised, particularly raised by the Honorable Lani Single Bench in the order that whether your service is protected by any law or not, you show.
Kindly see 257.
Milord, that staff benefit fund, your lordship has stated very rightly, the whole rightly that staff benefit fund has not been made the party. This is the real answerable party. Staff benefit fund committee is the appointed, milord, if you see the appointment letter, my staff benefit committee is the authority to appoint this person. Now, regarding the regularization, he cannot praise the railway to that you regularize this person.
I am never seeking regularization, my
And if you not regularize, you are how can you claim the salary?
He is working the staff.
Working under staff benefit fund committee. So how?
The members of that.
Yes.
My officer, kindly see the appointment letter once. That is, I am showing before your lordship.
Kindly come to page 257, my lord.
তোমার বলা হয়ে গেছে তো।
পাবে তো তুমি। Page.
পেজটা কত জানো?
Appointment letter 79.
79.
Page 41.
Milord, kindly see who is the signing authority. Kindly see page number 42.
Yes, you have. Where is that letter? You are showing page 171.
Yes, Milord.
That 18th of March 2013. You are saying that 14 days notice was issued.
Milord. He was coming. Milord,
Did not argue before the trial court.
Milord, no, it was 14 days. This point was raised before the Honorable Lanet Single Bench. But Lanet Single Bench disposed this of on the issue that your appointment has been made under staff benefit fund committee. You cannot claim a regular to be a regularized person under the railway authority. That is why, Milord, that has been dismissed. But Milord, one thing I want to show before your lordship. These letters has not been annexed. Milord, kindly see my affidavit in opposition. Kindly come to page number 163, paragraph number 4 of my affidavit in opposition.
Page 163.
3.
Yes.
My lord, from paragraph number 4.
Yes.
It is stated the Railway Board, height their letter number 27/2003, issued instructions that such homeopathic.
This also you could not produce. 2nd July 2003 circular.
Not annexed.
Are engaged by SBF committees and not by railways.
But it has not been denied, my lord. It is also not been denied by the appellant. There is a circulation. The appellant is not still before this honorable court is not denying. There he is saying since I am appointed in 79, I am regularized by all the circulars. My lord, just you have submitted.
I am
to
not
honorable.
seeking any regularization, my lord. What my learned friend is saying is on the basis of old circular which do not exist at present. 2014 governs the field. It is their circular they have said that my service should not be disturbed except through due process of law.
Yes,
This is the only thing.
due process of law, eviction.
They could not show the letter of termination, 14 days letter of
Lord,
intimation
there are letter of
anywhere.
termination. My lord, my learned adversary has also shown the letter of termination with effect from 2014.
2016.
No,
16 they're saying that they have issued a letter but given a retrospective effect. But that was also not produced.
So Hardy.
Only for payment of salary. But payment of salary, when appointment is made by that fund committee, how can railway pay the salary? Initially, who was paying the salary?
Railway.
Staff
Staff
benefit
benefit fund.
staff benefit fund.
Staff benefit fund maintained by whom?
Maintained, my lord, staff benefit fund is a committee which is maintained. But I'm just answering your lordship.
But from and out of the fund, they
Fund out of the my lord, there are some matters, my lord. Funds fund arising out of some unpaid salaries, unpaid dues, railway different type of
Railway revenue.
revenues, etc. So there is no particular provision of salary. But the salary says salary out of this fund.
even this attendance register now he has filed in the paper.
My lord.
Are maintained by only the committee.
No, it is maintained by him. My lord, kindly see this. It is not signed by the authority. It is maintained by him forcefully.
The seal is of the railways. Kindly inquire, my lord. What my learned friend is saying. 257. This is the railways.
Anybody
Railway seal.
Seal can anybody can.
No, my lord. This cannot.
Yes.
I have attended. They have. This is the attendance register.
Where is the signature?
I should not.
One page.
One page. After that, my lord, what they are doing, after when I have annexed this, they have stopped putting seal. I have to send this through my post that I am attending my service. But this is the seal of the railway.
Admitting his service.
This is the seal of the railway which shows that I have been taken back in service.
My lord, these advantages was taken. That is why to stop.
They have not denied it also.
So with this, you cannot claim any that you were working because this
Yes,
is
my
not
lord. My lord is absolutely correct.
I have placed all the rules, regulations, my lord. And it is a find.
Rules, regulation.
There is no finding of the court anywhere that I am out of service.
What? Not wanting regularization.
Yes.
My lord, I only want to continue till my contract expires and let them at least pay my salary. This is my right to
Still pay. Tell us.
railway staff benefit fund.
Is the committee a party to it?
Yes.
Where is the committee a party to it, Mr. Roy?
But
today you are not claiming regularization.
I cannot claim.
You cannot claim.
I cannot claim.
Your argument is pay me the salary as I am working.
Yeah, workshop personal officer disbursing of
Disputed question which was rightly raised by you in the suit. You rightly filed the suit. Now in the suit, in the meantime, when the High Court passed an order in that eviction proceeding, you withdrew the suit. That was a wrong instruction given.
No, my lord. No, suit was withdrawn after we pointed out before the honorable landed single bench.
All the facilities will be stopped. For that also, he has not taken any steps.
My lord, could only appreciate one
2013.
अरे यार को तो
Yes.
बोलना
That the
बोलते दाओ।
facility stopped in the year 2013 or 16.
13
Very
in the year 13 my lord,
Reintroduced
I
in
have
2020.
আরে বলতে দাও আমাকে আমাকে জিজ্ঞেস করছে
Which page number?
page number my lord, just I have shown before your lordship my lord page number no my lord at page number 171 the letter dated 26 March 2013.
From that date, all the facilities stopped.
Yes, that was stopped. Only quarter.
1 second. All the facilities by enjoying the railway, that PTO pass and all stopped. He has not taken it.
No, at all. Only, my lord.
Taking steps to evict him, that time only.
That has been here, and he was running the dispensary. We gave the respect to the honorable court. We allowed him to do it, and he is in occupation of the quarter.
Now,
Why?
is there any homeopathy doctor working still there?
No, not at all, my lord. I don't have any
No, my lord,
information.
there are other doctors who are enjoying the same facilities. I have indicated
My lord,
those
later
names
one.
in page
আরে
258.
বাবা, আমি বললাম, আমায় জিজ্ঞেস করছেন তো। Later on, some doctors has been appointed only on the temporary basis as for 4 hours working. Only 4-hour working basis, my lord. Since
That is appointed by committee or by
258.
committee, only committee, my lord. Railway doesn't have any direct action over here.
Sorry, Mr.
And only one thing, my lord, I want to say that as because, my lord, kindly appreciate only one aspect. My lord, this bungalow and the medical dispensary is directly related with the employment, my
We
lord.
have taken note of
But and they also have not challenged that particular aspect before the Honorable Apex Court. They have also
Not
admitted
required.
that I am still in service. That is the reason official quarter
Not
was
required,
restored.
not required.
Tomorrow we will pass the order.
Grateful. AM fixed আছে 11 AM fixed আছে
কালকে কি বার?
কালকে
বৃহস্পতিবার কি আছে?
না ফিক্সড কিছু নেই
বৃহস্পতিবার আমাদের কোনো বেঞ্চ নেই অন্য কারোর সাথে? বৃহস্পতিবার fix it up. The learned advocates appearing for the respective parties have concluded their arguments. Release the matter as for orders in the daily supplementary list of this court on Brihaspatibar day. On 4th as fixed at 1
tomorrow only
p.m.
Wednesday. Tomorrow only Wednesday. Day after tomorrow.
1 p.m. Fixed at 1.